We are now recording.
Thank you, Board Secretary. Good morning, everyone. My name is Jose Cisneros. I'm the Vice Chair of the Board of Trustees of the California State Bar. I am opening the meeting of the Board of Trustees for today, May 9th, 2025. It is now 9:02 a.m. here, and I will call the meeting to order. As a reminder, this meeting is being recorded. Board Secretary Lisa, could you call the roll, please?
Yeah. Barahona,
Present.
Buenaventura, not present. Cisneros,
Here.
Good,
Here.
Grande, not present. Gore,
Here.
Harrison,
Present.
Huser,
Here.
Soel,
Present.
Stevens, not present. Tony,
Present.
Trejo, not present. Stallings, not present. You have a quorum, Vice Chair.
Thank you very much. Next on the agenda is the call for public comment. Before we begin public comment, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or related to the matters that are within the jurisdiction of this agency. Specifically, the board is the state bar's governing body and is responsible for oversight of the state bar. Additionally, we have a full agenda today. As the Vice Chair of the board, we reserve the right to limit each speaker's time to 2 minutes or to close the public comment period after 2 hours, which includes a 10-minute break, or after the first 100 speakers, whichever occurs first. I believe we have 52 individuals signed up in advance for public comment. We do have a very heavy agenda today, and we reserve the right to reduce the time to 2 minutes per the State Bar's public comment policy. Board Secretary, can you identify the number of remote commenters who wish to speak?
Currently have 11 who have raised their hand to speak.
Very
That
good.
number is going up. I do apologize, Vice Chair, but that number is going up.
Okay, thank you, Lisa. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the board, please click on the hand icon now, and State Bar staff will call on you in the order the hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key on your phone, then the number 9. Again, doing so will alert staff that you would like to make a comment, and State Bar staff will call on you and open your microphone so that you can address the board. For those who are participating in person from a notice location, please alert the State Bar staff member present in the room that you would like to make a comment. Due to time restrictions, we cannot allow, in this case, more than 2 minutes for each speaker. Please note that the staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash to the final 10 seconds, and the board secretary will announce when the 2-minute timer is up. Please focus your comment on items that are on the agenda or relate to matters that are within the board's jurisdictions. As a reminder, your comments should be focused on items that are on the agenda. The board appreciates your participation and perspective, and so I think it's time for us to begin. Louisa, would you like to call on the first public member that would like to speak?
Yes, we'll begin with those attending from the Los Angeles office. So if you'd like to go ahead, just identify yourself, and we'll have the timer on screen. Folks in the Los Angeles office, would you like to provide public comment? Okay.
Honorable board members, my name is Victoria Tulcidas, and I'd like to be unequivocally clear. I am not a failure. I am not this test. I am a wife, a mother of 5, a human rights consultant, an entrepreneur, a relentless advocate for justice, and today I demand to be heard. What happened to me was not a minor glitch. It was a collapse. I was robbed of the moment I had earned, robbed of the word pass. My children, my family who sacrificed so much alongside me were robbed of the joy, the pride, the exhilaration of watching their mother succeed. Instead, I was handed fail, not because I was unprepared, but because the system failed me. In July of 2021, my computer crashed during the remote exam. Houdini, the psychomagician or psychometrician, deemed me a probable failure, and I was dismissed and issued a refund of $900, as if it could replace the time, energy, and emotional toll invested. But I didn't fail. I never failed now, and I didn't fail then, and I didn't fail now. You failed me. This February, I took the bar at your office. Mid-essay, the state bar issued laptop froze and crashed. After several minutes of the proctor and I trying to troubleshoot the issue, the computer had to be physically replaced. This created extreme stress and pressure in the middle of a critical testing moment. Throughout the exam, there were 5-second lags as you typed, repeated pop-ups, and no copy and paste, and no side-by-side view, and botched access to the PT library. There was no meaningful on-site technical support. Then during the performance test, the proctor, clearly perplexed, told me to wait for support and never returned. I waited and then did the only thing I could. I paraphrased the limited case law I could recall and attempted to analyze the facts to avoid submitting a blank answer. And still somehow I received a 45 on a PT, a score I had never seen in my testing history. That score reflects chaos, not competence. And yet, despite all of that, my overall score came within reach of the passing benchmark. My final scale score was 1380.2. I scored 1459 on the MBEs. I demand an investigation.
Your time is up. Next speaker, please.
Good morning, board members. My name is Justin Jennings, and I'm here to speak on agenda item 3.2. Point blank, the PT was not, in my opinion, I don't think anyone that took the test opinion, an adequate assessment of what we could do. We are unfairly prejudiced by the fact that the system glitched and we had numerous problems. I myself took time this morning to come from work. I had to take time off to take the test. I had to take time off to study. And I work as a paralegal where on a daily basis, I complete the tasks that are asked and required in the PT. I knew going into the test that that was going to be a strength of mine, and I prepared in that fashion. That test in the PT part became a test of memorization, which is not at all what it was designed to do. Given the constraints, there's no way anyone could memorize what was on one page, close out of that window, go back to the next page, and then adequately or accurately type what they thought they remembered. There needs to be some type of remedy that addresses that. We have always, most of us or all of us have always been taught to at least submit something so that we don't get a blank answer. And by submitting the inadequate answer or response we put, we were disproportionately penalized. I calculated it myself using your metrics and numbers as best I could. I would have gotten at least a 10-point increase if I would have left the answer blank. That should not have happened to anyone. So thank you for your time. I appreciate you at least doing something that adequately addressed the PT portion specifically, if you can. And again, I thank you for taking the time to hear us.
Thank you. Next speaker.
Good morning. My name is Ali Abedi. I'm actually, I'm a law office study program candidate. So the odds are already stacked against me. I took the exam in July 24. I barely missed the pass. I took the exam again in February 25. As you've heard from everybody else, I want to particularly focus on my performance test experience. As I'm sure all the attorneys here know, when you go through these courses that you're supposed to take for preparation, there's scenarios that you set up leading up to the exam, your testing conditions. You don't go in there prepared to have the software glitch. You don't go into the performance test expecting the copy and paste, the most essential function of that portion of the exam to not work, okay? To the point that the proctor saw me flustered and frustrated as I'm taking the exam. He interrupted me himself to see if I'm okay. And then they paused my exam till I finished my performance test at 8 p.m. Pacific time. So I don't know in what scenario in anybody's preparation that we're expecting that type of experience, okay? Now, my biggest issue now is that I'm being penalized because I completed the whole exam. The proctor came in at around 7 o'clock and said, just do the best that you can. What is the best that I can do? First of all, you can't view both portions of the exam. So as we were saying, you have to memorize the law and then go try to type it in. It's impossible. That portion of the exam is impossible to complete without copy and paste. I'm sure you all know that, but it was expected of us. So now we're being penalized for making a good faith effort to complete the exam, whereas other people are getting the benefit of the doubt and getting these imputed scores. So now I feel like, why did I even finish that portion of the exam? I should have just left it blank, and based on my score, I would have for sure passed. So I would like everybody to just imagine if they were in our shoes when they were taking the bar exam, and imagine how you would feel if that was your experience. Thank you.
Thank you. Next speaker, please.
Good afternoon, members of the Board of Trustees. My name is Seren Aytekin. I'm here to speak on Agenda Item 3.2, as everyone else did. I'm here today to respectfully request justice for myself and for many others who faced extraordinary obstacles during the February 2025 bar exam. First, I ask for consideration of my July 24 performance test score of 75, which accurately reflects my capabilities under standard testing conditions. I also request equitable relief for the documented procedural failures that robbed me of a fair chance to demonstrate my competence in February. On day one, the measure provided laptop malfunctioned repeatedly. I lost 30% of my typing time during essays 1 and 2, and nearly 50% of my time during essay 3. Despite intervention, my responses were left in safe status limbo with no confirmation they were properly recorded. On day 2, during the performance test, I had extra time. My exam tab disappeared, exposing my desktop, a serious security breach. I lost over 4 minutes of exam time and later found out that my written responses in the PDF annotations could not be extracted, despite being told they would be. My PT was considered largely blank, not because I failed to complete it, but because of a confirmed procedural breakdown. I am not alone. Some multiple choice questions were drafted using ChatGPT by non-legally educated individuals without the Supreme Court's oversight. This compromised the exam's integrity for all of us. We were not tested on the law. We were tested on how well we could navigate this function. I respectfully ask the board to consider my July 24 PT score of 75 for my February 2025 results and a one-time passage for those who failed by 80 points or fewer or who experienced those procedural breakdowns. This is about fairness. This is about restoring trust in the licensure process. I urge you to make it right. Thank you for your time.
Thank you. Next speaker in Los Angeles. Would you like to speak, sir?
No, because there's no items that I want to speak on. And I think one of your members, Executive Director Leah Wilson, demonstrates how they've handled my complaints, multiple complaints. And also a missing $2.3 million probate in the Superior Court with a judicial kind of like, I don't want to say cartel, but that's how a San Diego professor has an article regarding this enterprise. Thank you.
Thank you so much. Next, we'll move to the San Francisco office. Trustees, are there anyone from the public who would like to speak?
I would like to be more towards the video.
Yeah, do you wanna,
I'll just, yes, just so they can see.
I think,
And then cameras at the bottom there.
okay,
Maybe
maybe,
here,
Okay.
actually.
sure.
Yeah, thank you. Yeah.
Hey, at least we were heard. Great job, everybody.
Thank you.
I
Good
remember
luck to you
you.
all.
Yeah.
Yeah,
Yeah.
Okay, okay, very good. Good morning, Board of Trustees. My name is Katie Imani. I took the February 2025 bar. I failed by 8 points. The day I took the California bar, my ADA rights were violated. Prior to the exam, the California bar approved testing accommodations due to a learning disability. and I was granted time and a half for all sections of the exam. However, the day of the test, the proctor informed me that I would only be allowed the standard amount of time for every section. Again, I failed by 8 points. My final score did not receive any boosts. I did not take the experimental exam in November, so I didn't receive any extra points for that. I also did not receive any score imputations from the psychometrician. However, there were problems that the psychometrician did not account for, most notably for me, my ADA violations. I know you are all tired of talking about remedies, and so are we. We are all tired of this exhausting, failed experiment that we trusted that the bar would solve before we took it. But the CBE did not do their job. The CBE did not talk about remedies besides provisional licensure. I'm here today to ask you to provide appropriate remedies for the non-passers of this bar. I ask the board to pass the test takers that has received a second read, potentially adding 40 points for all others, and for the takers that are so low, the option of provisional licensure without an additional exam. Please don't let me and those in similar circumstances fall through the cracks. I went to a great ABA school out of state. I am a 40-year-old that lives in San Francisco. I am the mother of 2 young boys. I don't have time or money to take this test again. I was ready for this test. I was more prepared than I've ever been in my life. My ADA violations caused me to fail this test. Please find additional remedies for the shocking technical and administrative failures of this test.
Thank you. Chair Stallings, hello. If it's okay with you, we can move to the trustees' respective locations to see if any member of the public would like to address the board.
Yes, please.
Trustee Soel, I believe there's a member of the public with you.
Yes, there is.
Okay, thank you. Hello, go ahead.
Good morning. My name is Kion. Last meeting, I talked about I received fake defendant information from Sacramento DA office for my father, Woon Kang-on's death. DA case number 99F08735. Both Attorney General and Sacramento DA ignored my complaint. I did send complaint letter to Mr. Robert Bronter and Mr. Tien Ho. I ran into Attorney General 2 times at Sacramento. On April 2nd, I went to Mr. Bonter's office in San Francisco, dropping off a letter with the forgery document. I also dropped a letter into governor's office. I have protested at the front door of Sacramento Attorney General's office, Sacramento DA office, and Sacramento Superior Court. I even hand flyers to their staff. There's no reason for Mr. Tien Ho and Mr. Robert Bronter not knowing of my complaint. Their agency and they did not investigate my complaint is objection of justice and is criminal matter. I filed 2 complaints to State Bar of California. However, State Bar of California claimed my complaint is civil matter. I have emailed the forgery document to the State Bar board meeting coordinator. Please investigate my complaint. State Bar case number 25-0-1266 and 12612. It is about DA case number 99F08735 with fake defendant Jungso Fong. Also, please look into if any political power is interfering State Bar of California to dismiss my complaint. Sacramento City Council even asked a UC Davis student internship to email me a forgery police report. Sacramento City Attorney Office is involved, and Sacramento Mayor knew my complaint. Thanks for upholding the justice.
Thank you. Are there any other members of the public who would like to address the board from the trustees locations?
There are no more members here in of the public here in Sacramento.
Thank you.
You don't? No, we just. Okay. Okay.
San Francisco, is there a member of the public who would like to address the board?
No, there are no others here that are making public comment.
Okay, thank you. Chair Stallings, if we may, we can move on to those who signed up in advance.
Yes, please.
First speaker, we have Andrea Lynch. Your microphone has been enabled. Hi, your microphone has been enabled. You just need to unmute yourself. Okay. We'll move on to the next speaker, phone number ending in 6289, not present. Next speaker we have is Jenna, not present. Next speaker we have is Tommy, not present. Next speaker we have is Angel Ahala. Your microphone has been enabled.
Thank you very much. My name is Angel Jala, and I'm a 5-time California bar examinee. I've never failed the performance test. It's always been my strongest section until February 2025. I was 20 minutes into the PT when my proctor stopped me, claiming he couldn't hear me, even though I had not spoken. I was sent to tech support, where I lost over 30 minutes with a frozen clock, only to be told that nothing was wrong. When I was returned, my exam clock remained frozen, and no one, not even the new 15th assigned proctor, could tell me how much time I had left. As a retaker, I knew one thing: submitting something is always better than leaving it blank. AD Advising says it, Themis says it, Bar Exam Toolbox says it. Never leave an essay blank. Touch every issue, attempt every section, because submitting nothing is a guaranteed fail. So I did what I was trained to do. I fought through the chaos and submitted something. Rushed, scattered, incomplete. And that's exactly why I was excluded from the only remedies the bar offered. Only 45 people total received score imputation, not because only 45 were impacted, but because the bar designed a remedy that applied only to those who did the exact opposite of what we were all trained to do. That wasn't just unfair, it actually may have been unlawful. California Business and Professions Code 6046.6A prohibits the examining committee from altering the bar exam in a way that requires a substantial change in training or preparation without 2 years' notice. But that's exactly what happened. We were trained for one exam and graded on another. No notice, no consistency, no compliance. And let's talk numbers. Over 4,300 examinees, 95% reported technical or proctoring issues, only 90 were offered retakes, and only 45 total received score imputation. That means 98% of us were told to suffer through it anyway.
Apologize, but your time is up.
Thank you. I will just lastly say that the remedy I am asking for is a flat pass rate of a 65 to be imputed to all PTs. They should not have been graded in the first place. And
But your time is up.
Thank you. I said it. I appreciate it.
Next, we have Darlene Boggs. Your microphone has been enabled.
Hello, I wanted to say that the February bar was not merely chaotic, it was fundamentally unjust. Before the exam, the state bar created needless stress through inconsistent and confusing communications. Examinees received contradictory instructions. Test centers were assigned last minute, forcing applicants into unnecessary logistical panic precisely when we should have been studying. On day one, I faced immediate technical failure. My assigned laptop had no internet connection. Multiple proctors struggled unsuccessfully to fix the issue, while most of my peers had started their exam, ultimately moving me to another seat. This delayed my start time significantly and interrupted those applicants around me. There was no clear proctor instructions. Examinees began at different times, causing continuous disruptions and confusion. The software lagged severely, slowly typing and editing to anxiety-inducing moment. The performance test lacked basic functionality, including working copy and paste feature. During essay 4, my screen froze completely for over a minute, erasing critical annotations. I raised my hand immediately, yet received no assistance. On day 2, the disruptions worsened. Both morning and afternoon, multiple choice sessions started late, causing additional stress, fatigue, and frustration. After these issues were eventually resolved, many examinees received the full time allotted plus an extra 20 minutes, clearly advantaging them. The questions themselves were halfly written, error-filled, and significantly different from the studies materials we were giving, further disadvantaging those who have rigorously prepared. The bar labeled this exam part of the California bar experiment, yet February examinees received none of the benefits previously provided to participants participants in the November experimental test, such as additional points or as claimed prior exposure to question. The bar has selectively granted relief to examinees who left essays behind.
Time is up.
Yeah, I pretty much am asking that second pass, second re-examination should be passed and that everyone else should receive points to the next administration or appropriate relief.
Thank you. Next speaker is Catherine Valle. Your microphone has been enabled.
Good morning. So I'm here, I'm February 25 taker. And yes, I'm echoing pretty much what everyone else has said. PT had detrimental flaws. I am always been a strong PT taker. During the first 5 to 10 minutes, I couldn't access the file library. I don't know why, and I had to get switched around proctors just so they could figure out where the file library was. And even cost them having to log me out of their browser and put me through Google Chrome so they could find it. So I lost the majority of my time there. And on top of that, the copy paste function didn't work. Even when I put it in the notes on the page itself, wouldn't do it anyway. So I'd have to write on this little whiteboard that I have in front of me as much of the laws as I possibly could, or any sentence, and write as small as possible so I could try and look back on it and put it into my PT. Also, the MCQs that were detrimentally flawed. The logic behind it was just completely off. I've been taking this bar exam 4 times now, and I've seen all the multiple choice. They pretty much all look the same. These ones did not at all. Wasn't at all what I studied, and it just feels like we were kind of set up to fail from the start. We warned you guys that this test should not have gone through, and you guys ignored it anyway. So I'm asking for the appropriate remedies. Second reader should pass, and then everyone else should get a provisional license without needing to take a retake. Because why would we need to retake the bar exam for something that was entirely the bar's fault and letting happen? Because you guys are now suing Measure Learning, and now the Judiciary Committee is looking into what is going on with the exam in general. So something needs to be done. This needs to be fixed, and it's not at fault of our own. We were just kind of set up to fail, and the people who took the risk shouldn't have to just suffer the consequences for a very flawed exam. Thank you.
Thank you. Next speaker is Tao D. Your microphone has been enabled. Hello, your microphone has been enabled. You just need to unmute yourself. Okay, we'll move on to the next speaker. We have T, not present. Next speaker is Diva Ladva. Your microphone has been enabled.
Good morning. My name is Diva Ladva, and I was unsuccessful in the February 2025 California bar exam. I'm here today to suggest 2 possible remedies, with the first pertaining to the written portion of the exam and the second pertaining to the MCQ portion of the exam. In regards to the PT, that was riddled with errors from the get-go. As mentioned in previous meetings and documented by this board, over 90% of applicants faced technical issues throughout this entire exam, specifically during the PT. Because of this, I'm requesting this board to impute this PT score by averaging the essays 1 through 5 and replacing the current grade with that average, or giving all applicants a universal score of a 65, whichever is higher. In regards to the MCQ, this portion of the exam lacks transparency and lacked transparency from the very beginning. The only remedy that is fair would be, again, to impute each applicant's lowest category score with an average of the remaining categories. I earned a score in the 73rd, 68th, and 58th percentiles in constitutional law, torts, and civil procedure, respectively, while to then earn a score in the 1st percentile in criminal law. We all learned these questions were drafted by AI just a few short weeks ago. This portion of the exam has been riddled with a lack of transparency, and it has been heartbreaking as an applicant to take and listen to and sit through. I was unsuccessful in July of 2024. However, I failed that exam with grace because I worked for 4 months to learn why my score fell short, and I was able to see and improve. I went from earning a lower score to being within passing range on this exam. to average at least a 65 on essays 1 through 5 to then suddenly earn a 45 on a PT is unjust, when even if an applicant had no technical issues, there is no way for an applicant to earn a score that is expected on a PT exam without the ability to copy and paste, without the ability to highlight a physical file that has been done previously, with an exam that was fundamentally flawed and changed from the get-go. So therefore, I please ask this board to address both remedies at both sections because it is unjust to do so without it. Thank you so much for your time.
Thank you. Next speaker is Lubna. Your microphone has been enabled.
Hello, do you hear me?
Yes, thank you.
Okay. I was in person taker using the laptop provided by you. I did not pass by a couple of points. The main reason for that is the performance test, which I scored 45, which the bar was aware that I encountered technical difficulty that prevented me from administrating the test for the first 20 minutes, as I sent an email and complaint on the administration website. Above that, throughout the whole test, my highlighting function, copy and paste were not working, and I would need to write about 5 words for the words to appear on the screen. Not to mention that I was in Ontario Center where people were fed up with the administration of this exam, so they were screaming at the proctors and slamming doors, which affected my ability to focus. Regardless of all of that, all my essays were scored from 65 to 70. The only reason I failed is the performance test that was not imputed from me, but was imputed from people who did not write anything on an essay. How is this fair? I have already showed my competency through the 5 other essays, notwithstanding all the difficulties that I have encountered while taking this whole exam. I demand a fair and equitable remedy that would allow me to practice. Either pass people who have scored within 5 to 100 points of the passing score, pass people who have a second read, or give us all a provisional license without a retake. And please do it fast because our lives depend on it. Thank you.
Thank you. Next, we have a phone number ending in 9912. Your microphone has been enabled. Hi, your microphone has been enabled. You just need to unmute yourself.
I was a first-time taker in February. Going into this exam, it was a high-stakes exam for me. My wife and I made a difficult decision for our family. I took 3 months off without work, without pay, and we lived off of our savings. I knew I had one shot at this, so I gave it everything. I studied 13 to 14 hours a day from 7 a.m. to about 10 p.m. I was scoring in the high 70s on the practice MBAs. My essays were strong, and I felt confident I would pass. When the scores came out, my written scale score was above 1550, but my multi scores were split. I was in single digits in 3 subjects. Ironically, my contract essay was at an 80. My contract multis, 1.6 percentile. That is not a coincidence. I'm almost positive if you look at my multi scores, I can guarantee you will see my score started to suffer right around the time we were unable to save answers and ultimately when the server crashed. And that's essentially when things unraveled. I sat at my laptop for over 90 minutes, unsure if it was just me having issues or if it was everybody. The proctor told me to sit tight. Sit tight, my future was on the line. When the server finally came back on, I couldn't focus. My heart was pounding. My mind was all over the place, and I was reading questions over and over again. I could simply not focus on the exam. I rushed through the final sections 3 and 4 of the exams, hoping to get it done just so it doesn't crash on me again. Psychometrics does not measure for this kind of stress, but it changed the outcome of this exam. I urge the board to consider passing second readers who earned at least a 1350 or a PL without a retake. There was precedent. This was done in 2020. As for July, I'm registered, but I will likely withdraw. I can't afford to take time off work. My wife and I will have no money to support our kids if I take off work again without pay. I'm truly devastated by this. I put everything into this, and the bar has just failed me and so many others. I'm sorry. That's all I've got. Thank you.
Thank you. Next speaker is Oluwatomi. Your microphone has been enabled.
Hello. Can you hear me?
Yes, thank you.
Well, thank you for the opportunity to speak. I was a February 2025 bar applicant. Specifically, I want to highlight how the performance test was disproportionately more difficult under the conditions we faced and how the current remedy creates a 2-tiered system of unfairness. The PT differs fundamentally from the other 5 essays. It's designed to test applied legal analysis under real-world conditions using a packet of source documents, statutes, and case law. That is why it carries double weight over other essays. But due to the technical issues, especially the inability to use copy and paste, annotate, or view multiple windows simultaneously, this exam section became uniquely unmanageable. Candidates had to toggle between different screens without copy and paste, which made the test become more of a memorization exercise. As a result, many examinees who would have otherwise or who demonstrated competence across essays 1 through 5 received drastically lower scores on the PT, an outcome that is now evident because of the published results. As for the remedies, the Bar Association imputed scores for applicants who could not submit answers due to the technical issues, using an average of the performance on the other essays 1 through 5. However, those who managed to write something under impossible conditions were held to the full grading standard of the PT. This creates a fundamental unfairness. Those who wrote the PT were judged based on a version of it that was more difficult to execute, and those who could not write anything at all were given imputed scores based on performance on questions that were less logistically burdensome. In other words, the imputed PT scores reflect the relative ease of essays 1 through 5, not the compounded difficulty of a broken PT environment. For equity's sake, I say an applicant who attempted and completed the entire exam scored a passing average on essays 1 through 5 and failed solely because of a lower PT score, which I'm in such group, should be eligible for
Apologize,
PT
but your time
reassessment,
is up.
adjustment, or
Thank
imputed
you.
score of.
Next speaker is Shyam Patel. Your microphone has been enabled.
Hi, can you hear me?
Yes, thank you.
Thank you. Good morning, trustees. My name is Shyam Patel. I'm a licensed attorney in California. I'm here to speak on agenda item 3.2. The administration of the February 25 bar exam has been a profound failure from the inception to the release of results, to the use of AI-generated questions to the remedies provided. This continuous mismanagement places the burden squarely on test takers who rely on the CBE to uphold the fair and equitable process. At the CBE meeting this past Monday, critical remedies, such as passing those who qualify for a second read or considering prior performance imputation, were dismissed as too difficult to figure out. In the remedy they proposed, provisional licensing without a pathway to full licensure is the same framework established as for 2020 law graduates during the pandemic. This approach required minimal effort to implement, a convenient solution for a crisis far worse than anything experienced by 2020 graduates. If more comprehensive remedies were deemed too complex, why settle for the easiest option that offers no path to full licensure? Even more surprising, provisional licensing was extended to applicants who withdrew from the exam, despite them already receiving a refund and a free retake. If the CBE is unwilling to pursue more comprehensive solutions, does that reflect the same lack of planning and oversight that led to failure of this exam's administration? The meeting was spent celebrating a high passing rate without any real breakdown of how imputation or grading or lower PT scores impacted those numbers. We had 1,066 applicants withdraw, yet the impact of those withdrawals wasn't even mentioned. Instead, statistics focus on demographics, completely irrelevant to the remediation. Meanwhile, those who wrote even a paragraph or two on the PT were harshly graded, while those who left essays completely blank received imputed scores, something higher than those who actually wrote something, despite having to shuffle between 2 separate tabs advertised as an advanced feature of measure under the same time constraint. This inconsistency punishes effort and rewards blank submissions. A one-size-fits-all approach is neither sufficient nor just. Group A was given imputed score. Group B was offered retakes. Group C, those who desperately tried to capture every possible point under flawed conditions, are punished the same broad brush remedy of a lower raw passing score. Where is the equity? Where is the accountability? I respectfully urge the trustees, I'll just conclude in a minute,
Thank
in
you.
2
Your
seconds,
time is up.
to pass all applications.
Next speaker is Rudolph Phyllis. I do not see Rudolph Phyllis in attendance. Next speaker is Harul Turnquist. Your microphone has been enabled.
Can you hear me?
Yes, thank you.
I'm an attorney who passed the New York bar exam on my first try and have already practiced law in good standing for over a decade. I took the February attorney exam, which was not a valid test of competence due to severe continuous tech failures all throughout my exam. I was granted disability accommodations because I was assaulted by a stranger shortly after moving to California and now live with impaired mobility and substantial distracting pain. My accommodations included extra time and an environment which minimized distractions, but instead I experienced lost time and greater distractions in violation of the ADA due to freezing, lag, disconnections, errors, blurry text, non-visible clock, no copy and paste, and proctors. Due to my disability schedule, I did my PT on day 2, which is when the most severe server problems occurred, whereas non-disabled examinees did their PT on day 1 when disruptions were less severe. As a result, I suffered the discriminatory impact of unfairly failing the PT with a score of 40. I was only scored on my essays in PT, so the PT was worth the most points for me, and its low score dragged me down, causing me not to qualify for a second read and to fail the exam, even though my answer contained substance and analysis. People with blank PT scores did not demonstrate ability to handle legal authorities in the context of a factual problem, which is what the PT tests, yet they received high imputed scores and passed, while I had severe disruptions but wrote something, so I failed. An appropriate remedy is replacing the PT score with the required minimum passing score of 65. Another appropriate remedy, which the CBE voted in favor of on May 5th, is admission on motion without examination for out-of-state attorneys because 1, we're already competent, we've worked as attorneys, and our good standing gives no reason to doubt competence. 2, attorneys licensed in D.C. for 3 years can be admitted on motion in D.C. and use their D.C. license to waive into states that have reciprocity with D.C., which is almost all other states. So out-of-state attorneys deserve the same benefit in California. And 3, California Assembly Bill 1522, which may be signed soon, states that out-of-state attorneys licensed for 4 years should be admitted without examination as a public interest emergency because there's an urgent need for them to fill vital legal positions within the state. Lastly, please create a special remedy for the disabled because this exam stripped them of their accommodations and abused them.
Thank you. Next speaker is phone number ending in 3145. I do not see that person in attendance. Next person we have is Alicia C. I do not see that person in attendance. Next person is Pilar Hernandez. Your microphone has been enabled. Thank you.
Good morning. I respectfully, I know all of you have listened thousands and thousands of complaints. You already know, you already have a huge list, the issues that each applicant face. I believe no one applicant faces the same technical issues than others. Today we are hearing more about PT, more about second readings, etc. I personally I was in Ontario and I have 1 hour and 10 minutes, 48 minutes for 3 essays. I decided to split my time and respond each essay in less than 40 minutes. You cannot compare my score with another person that had more time or probably less time or wasn't able to submit any work on those essays. Everyone who sat for this exam was subject to deeply flawed, chaotic, traumatic testing experience. The entire process failed us. Every applicant, regardless of whether they were able to submit answers or not, deserve equal remedy. So I'm here to ask you how you can compare my score with other people that also failed or passed without gave us or guarantee us the same circumstances. All of us face completely different issues. And I decided to go through given the circumstances, and I decided to type and I decided to read questions in less than 1 minute, just reading and try to respond so fast as to gather much point as I couldn't. And I'm being punished for that. I really appreciate if you consider. Thank you so much.
Thank you. Next speaker is Shannon. I do see a couple of Shannons. Oh, thank you. Shannon L. Thank you. Your microphone has been enabled.
Hi,
I am someone who passed the February 2025 bar exam, and I was just speaking on behalf of my fellow applicants and takers, especially those who did not pass. I would just like to advocate for a provisional licensure without a retake for those who passed within 80 to 100 points of the exam, and admission upon motion for those who are already fully licensed in other states. I believe the circumstances under which the exam was administered both in person and remotely was appalling, to say the very least. I personally could not copy and paste in my PT portion. I'm lucky that I'm a fast typer, but I feel like that's not supposed to be the standard upon which the PTs are graded, like how quickly you can memorize a rule and how fast you can type it out. I personally also had issues on the second day with the multiple choice not being able to log in, and I also faced issues with proctors basically allowing a staggered start for everyone. The fact that lunch breaks and the in between essay breaks were sort of arbitrary, despite there being a time limit, was infuriating. Knowing that people were often stepping out to basically review notes or taking extra time. I feel like that's never really been addressed, and ultimately, I feel like there should be a more flexible range of remedy options for people who failed the February 2025 bar exam, because there are so many differing circumstances, which means that no one solution will fit everyone equally. The fact that some people filled in essays in good faith and were scored lower based on that is frankly ridiculous to me. Thank you.
Next, we have Jay Camper. I do not see Jay Camper in attendance. Next, we have phone number ending in 7596. I do not see that person in attendance. Next, we have speaker by the name of Diana. Diana, your microphone has been enabled. Your microphone has been enabled. You just need to unmute yourself. Okay, we'll move on to the next speaker. Next, we have Yinan Huang. Your microphone has been enabled.
I'm Ina Huang. I'm a retaker, and I was fully prepared for the February exam, confident I will pass. But during the test, the copy and paste function on my State Bar issued laptop did not work. Unlike remote test takers with full functionality, I couldn't effectively move or organize tasks. This dropped my usual essay scores from the 70s to the 60s. And the performance test was most severely impacted. I had to manually write out entire rule sections that others could paste instantly. This took over 40 minutes, leaving almost no time to organize my answer. I scored a 50, far below what I believe I would earned under fair conditions, and even lower than blank submissions that received imputed passing scores. What I'm asking for, I urge the State Bar to adopt one of the following remedies. Firstly, impute the PD score as the average of essays 1 to 5, or assign a minimum PT score of 65 if lower, or automatically pass applicants whose essays received a second read. Why this is necessary? Because first of all, the PD copy and paste failure was not addressed adequately. The bar promised full functionality. The failure devastated in-person test takers like me, switching tabs and manually writing tests, gained time, and reduce answer quality. The current score adjustments don't fix this. Secondly, I'm a near pass candidate undone by a technical error. My essays were strong enough to receive a second read, but my PD score kept me from passing, despite demonstrating legal competence. Thirdly, the most importantly, good faith effort was penalized, while blank PTs were rewarded. I was told the issue would be handled case by case, but no remedy came. Those who tried under broken conditions were.
Next speaker is Jasmine Williams. Your microphone has been enabled.
Hello, can you hear me?
Yes, thank you.
So my name is Jasmine Williams, and I sat for the February 2025 California bar exam as a first-time test taker. I scored a 1384. So yeah, I scored a 1384. That means that after my second read, I didn't pass by 6 points. And after my first read, I scored a 1386.5, 3.5 points from passing. The average scores I received for essays 1 through 5 were 66.5 based on my operant grade after my first and second read. Yet, because I attempted to complete the PT under the same technical and environmental issues as those who chose or couldn't respond, I was penalized by receiving a score as though I completed the PT under the same testing conditions, not under the conditions that I experienced when completing the PT, such as inability to copy and paste, multiple screen layouts on separate screens, navigation challenges, lack of visibility of a timer, computer lagging, not to mention all the environmental issues that I experienced. Yet the people who chose not to respond or couldn't had a score imputed by a psychometrician for them based on their average essay scores. If everyone received the same privilege, test takers like me who were less than 10 points from passing would be able to celebrate and move forward with our lives after experiencing such traumatic testing experiences. Instead, we're faced with loans being due, housing and employment insecurity, and the stress of having to study and take another bar exam. When let's just say what it is, we passed. I'm urging the board to provide us with the same remedy as those who didn't complete the PT because we all experienced the same technical and environmental issues when trying to complete the PT. We need a fair remedy, which would be score imputation based on our average essay scores, especially for those who received a second read and those like me who are 10 points from passing. And we need that remedy to be applied immediately. We don't deserve to continue incurring damages while we're waiting to determine our fate. A reasonable amount of time would be 2 weeks, the same amount of time the California State Bar allows test takers to appeal for reconsideration of grades. And to my fellow test takers, let's be mindful of how we use this time and not
Apologize for your time is up. Thank you. We'll go back to Reuter Phyllis. I do see that Reuter is in attendance. Your microphone has been enabled.
Hi, can you hear me?
Yes, thank you.
Yeah, pretty much I suffer the same issue as everyone else. And the only problem I'm seeing right now is I urge the board, please come up with solution with completeness instead of drip, because those of us who fail, we already signed out for the July. However, I am in San Diego. When I signed up for the July bar, San Diego was not even an option. And then, we were promised with seats available for those of us who took the February bar and was waiting to be able to sign out for the July bar. And I also have a very unique situation. I'm a mother of 2 autistic children. I know what it takes to be prepared. I had 3 laptops all lined up that day, and I was going to make sure no computer glitches will stop me from completing the exam. However, because of the IT intervention, my computer firmware disabled 2 of my laptop, telling me they pick up suspicious activity. I was left with no choice but choosing the one that I know is going to freeze. Throughout the 6 exams, my laptop froze about 7-8 times until I gave up counting. And I calculate, average speaking, I lost about 5 to 10 minutes for each one of my essay. However, I pushed through the finishing line. I was not giving any imputation remedy. Even under this situation, I scored 270s and 260s. So I urge the board, if you are going to test us our legal skill for the performance test, make sure it's side by side with the question and also the library for July. And also with the remedy, if you can pick 4 of our score, like how you apply to the other people who couldn't even do the essay.
Thank you.
Also
your time
make
is
San
up. I do
Diego available.
apologize. Thank you. Next, we have, we'll go back to Jay Camper. I do see Jay is now in attendance. Your microphone has been enabled. Hi, your microphone has been enabled. You just need to unmute yourself. Okay, we'll move on to phone number ending in 5102. I do not see that person in attendance. Next, we'll move on to Vanessa Holton. Your microphone has been enabled.
Good morning. I was general counsel of the State Bar from 2015 to 2022. My comments addressed closed item 1.1 concerning State Bar participation as an amicus in the lawsuits listed against the administration of Donald Trump. Those lawsuits challenge the president's recent executive orders pertaining to the practice of law. His executive orders prohibit certain law firms from representing clients and causes the president disfavors and inappropriately involve the president in the operation of the firm's diversity, equity, and inclusion policies in their choice of pro bono representation. The courts in these cases have found that the firms are likely to prove that the president's actions are illegal, unconstitutional, and unenforceable. More than 800 law firms have joined as amicus briefs in support of the plaintiffs. I urge this board to authorize the State Bar to also participate in as amicus in support of the plaintiffs, or at the very least, to issue a very strong statement in support. The board policy manual provides that with permission of this board, amicus participation will be considered where the litigation impacts issues germane to the missions of the State Bar. By California law and its own strategic plan, the State Bar's central mission is the protection of the public. Another mission is support for greater access to and inclusion in the legal system. The president's executive orders threaten both these missions. Protection of the public requires upholding the rule of law, which is defined as a durable system of laws, institutions, norms, and community commitment that delivers accountability, just law, open government, and accessible and impartial justice. The rule of law is violated here, where a government uses its power to control who and what causes attorneys may represent, and then retaliates when they cross the government. As the largest state bar in the country, who is looked to and has been looked to for years by other state bars, I think the California State Bar should once again lead by defending the rule of law at stake in the listed cases and authorize participation as amicus. Good morning. Thank you.
Thank you. Next, we have Bernice Vanderpool. Your microphone has been enabled.
Hello, my name is Bernice Vanderpool. I sat for the February 25 bar exam. I am reaching out to you today on behalf of agenda item 3.2. I speak on behalf of those who were medically prescribed accommodations, and these accommodations were accepted for the 25 California bar. These ADA approved accommodations were violated. They were violated by those of us who sat for this exam. My own experience, day one, was supposed to be approximately 6 hours. Day one for my exam was 12.5 hours. I had no break for the first 6 hours. I was bumped off of the system multiple times. I spoke with proctors. I spoke with tech support. And throughout those first 6 hours, I begged to be allowed to use the restroom. Repeatedly, I was told if I left the room that I would be automatically disqualified and they would shut my exam. This happened to me on both day 1 and 2. Where I sat before this computer for over 12 hours without breaks. I did not even get to eat for 7.5 hours. It is, as professionals in the legal field, that the law provides fines, among other remedies, for these type of ADA violations. I'm appealing to the trustees that you step up with appropriate remedies to deter an ADA violation class action lawsuit from being filed. And in closing, I'm respectfully asking that, for the reasons I've stated, that there is a PLL with pathways for those of us who sat for the exam. Thank you.
Thank you. Next, we have Zaid. Your microphone has been enabled, Zaid.
Can you hear me?
Yes, thank you.
Hello. Good morning. My name is Zaid Tabani, and and I'm here today to seek justice and equitable remedies as I address the scoring. As I address the scoring remedies applied to this exam, and they don't equally and fairly apply to all the examinees, especially to those who. I'm sorry, I'm having a technical difficulties. Give me one second. Can you hear me?
Yes, thank you.
All right, thank you. Sorry, I'm here to address the technical issues that had occurred while I took the exam, especially to those who had were able to complete the exam. However, when I saw my scoring report, my scoring report showed that I had did well on all my 5 subject tested essays, and I had did well on the multiple choice. However, where things took a turn was the performance test. That's where most of my technical difficulties had occurred. I had taken the test at the Chula Vista Testing Center and I had raised my hand to inform a proctor. When finally a proctor came, she told me that the state bar had already known about this and she had advised me to make the most of what I could do. And that's exactly what I did. And as I reflect on this, I recall that in law school and in bar prep, we were told to make the most of what we can do, as writing something is better than writing nothing. When I had reached out to the state bar about possible remedies, I had suggested how about a good faith passing basis, but I also that's not plausible as it's the state bar's mission to pass people who are minimally competent. But as I reflect on this, how are people who are getting their scores imputed minimally competent? Because if anything, their imputed scores is just an assumption of what they have gotten. No one in reality will ever know what they have gotten. Therefore, I seek the Board of Trustees to provide an adequate remedy. Thank you.
Thank you. Next, we have Ray Hayden. Your microphone has been enabled.
Hey, cool. All right, thanks. Can you hear me all right?
Yes, thank you.
Louise, if my mic gets crazy, let me know and I'll shut it down or something. But anyways, I want to talk to 3 named parties I can think of right now, or I'm sorry, 2. Mr. Tony, because you're a business owner and you know stuff better than a lot of other people on any of the boards. Ryan Harrison, because of your participation in a BRC. I remember seeing you there. And also Chair Stallings and Director Wilson were at that meeting the other day. And the state judiciary demanded that you fix the entirety of the bar exam right now. Fix it right now. That's what she said. I got the video to prove it. Diploma privilege with quotes around it. This is my first priority at this point on, and why? Here's why. What does the bar exam test? Minimum competence. How do we qualify all around the world to sit for the California bar exam? Meet Cal Bar, Cal Supreme Court levels of minimum competence. We have to display minimum competence just to sit for a test on minimum competence. And February and quite a few others were radically incompetent. I'm not blaming anybody on that. You almost got it. It was the measure system was the problem. Now, the other one is my pathway, which I give away for free. And I've been talking to you since 2023 and you yet to do it. This is an equal admission process. And I would love to see happen because all of those who pass are about to learn upon admission that you are not good to go as a newly competent, newly licensed lawyer. You're not. I'm not, and I got 3 decades in litigation support. I got more time before judges than a lot of attorneys who have been practicing for 10 years have, okay? So I'm in the system. I know the system. In fact, people keep telling me I try to fail the exam. I don't, but I am playing with my answers, and my answers are freaking awesome. What I've been able to demonstrate is the greater subjective grading is flatly BS. Okay, that's being nice about it. And they do not read for. They don't read to find out what it is.
So your time is
Damn
up.
it. Go ahead. Go for it.
Thank you. Next, we have phone number ending in 1843. Your microphone has been enabled. Hi, your microphone has been enabled. You just need to unmute yourself.
Yeah. Hi, can you hear me now?
Yes, thank you.
Yeah. Hi, good morning to all the people present here. My name is Megha Sharma, and I sat for the California 2025 California Bar Exam. I scored 1389.3929 out of 1390. missing the passing score by just 0.6071 points. It is not even 1 point. That is less than one single MCQ. I have already submitted a detailed letter requesting reconsideration due to serious technical disruption I experienced during both the exam days. On day 1, I was allowed into the bar exam 40 minutes late, faced constant lag while typing, and could not properly access the PT library as there were serious technical glitches. On day 2, my MBE session froze for 20 minutes. I could not reach my proctor and was left helpless and in panic. In that experience, I scored 1389.3929. I just missed by 0.60 points. Despite all this, I came within a fraction of passing. Yet I'm not alone. Many second read applicants endured the same systematic failure, yet we are being measured against a standard that did not hold steady for us. Today, I respectfully ask the committee, not just for myself, but on the behalf of all the second read applicants, to take a just compassionate step. Please pass all those who got the second read, or take a extra special consideration for the PT session as we face a lot of technical glitches there. Our scores show how close we came. Our commitment shows
Your
we
time
belong.
is up. Thank you.
Thank you.
Next, we have Mike. I do not see anyone by the name of Mike with their hand raised. Next, we have Araik. Your microphone has been enabled. Hi, your microphone has been enabled. You just need to unmute yourself.
Are you hear me?
Yes, thank you.
Good morning, Board of Trustees. My name is Araik. I have been working as a judge in a foreign country for almost 11 years, and I understand justice and law very well. I studied in US. I graduated law school in California and started my new career from zero. New legislation, new law, everything is new. In February 2025 was my third attempt to take the bar exam. I did not pass because I did not manage to write my performance test. I read the library for 50 minutes and then I started writing it and I realized that the copy paste was not working. And additionally, you can split the screen. I called the manager and testing center and he tried to correct for me. Then he documented everything, that copy paste doesn't work and can't split the screen, and I lost at least 5-7 minutes additional. I only managed to write performance test, issue and rules. Next day during MBA exam, that was nightmare for me. It disconnected 6 times. 6 times. Several days after the exam, I had an emotional distress and anxiety, and after that, no any imputation and adjustment for that. It's not serious. To be honest, I lost myself when I saw my scores. So my performance test rated nothing, only 0. So I can say people who wrote at least a paragraph received a no score imputation. Meanwhile, who's submitted nothing were given imputation and in many cases passed. The Committee of Bar Examiners failed to offer any meaningful remedy for this serious error. And now they want to give us provisional license with the retake bar exam. And this is a fair? Of course, no, this is unfair. So I respectfully ask the
I do
Board of Trustees to
apologize for
make the
your time
decision
is
and
up.
give me a
Next, we have Sarah. Sarah Turpanchi. Your microphone has been enabled.
Good morning. My name is Sarah Tirpansi. I'm one of the February 2025 bar examinees, and I experienced firsthand the impact of the faulty multiple choice questions. English is not my first language. Despite this, I believe I demonstrated my legal competence by performing extremely well on the essay section. However, during the multiple choice portion, I encountered questions that were flawed and riddled with typos. Instead of recognizing them as errors, I doubted my own legal knowledge, thinking I must be missing something. After receiving my results, it became clear I performed strongly on the essays, but the multiple choice section brought my score down. Nevertheless, I received a second reading, showing just how close I was to passing. Given these circumstances, I believe that I and others who face the same challenges deserve a remedy. One important step would be to pass all candidates who received a second reading. This would fairly recognize the hard work and competence we demonstrated, despite the issues with the exam. Additionally, I respectfully urge you to consider how the flaws in the multiple choice section created an added burden for non-native English speakers like myself. It turned the exam into not only a test of legal knowledge, but also a test of language skills and typo detection, something that should never have been part of the bar exam. Thank you for your time and your consideration.
Thank you. Next, we have CJ Abraham. Your microphone has been enabled.
Thank you very much. I want to raise an important concern that may have not been fully considered when the decision was made to change the California bar exam for 2025. Thousands of applicants, many of whom speak English as a second language, as we just heard from Sarah, or third language, prepared for a nationally standardized exam, trusting it would meet state and federal standards of fairness and non-discrimination. By introducing a new format that included typos, grammatical errors, and significantly altered wording from previous bar exams, the bar inadvertently created barriers that disproportionately impacted non-native English speakers. Whether intentional or not, the result was an uneven playing field. We don't need to debate the science of language processing. The simple truth is the risk should have been identified and eliminated, and based on the board's own admission, it wasn't. This isn't just a failure in quality control. It raises serious questions under anti-discrimination law. As members of the legal profession, it is your duty to ensure equal access and fairness in every part of this process. I urge you to investigate this further, to review applicable laws, and to consider remedies for individuals who may have been unfairly disadvantaged.
Thank you. Next, we have phone number ending in 2488. I do not see that person in attendance. Next, we have Daniel Gregorian. Your microphone has been enabled.
Can you hear me?
Yes, thank you.
Yeah, thank you very much. My name is Daniel Gregorian, and my question concerns item number 3.2. I am first time taker of the February 2025 exam, and I am foreign trained lawyer with over 17 years of experience in international arbitration. I have dedicated myself to the exam with sincerity, hard work, and of course determination. Until now, I have never publicly spoken about the issues I personally faced during the exam. I know these problems have been widely discussed, and I don't wish to repeat them here. However, when I received my score, I was shocked, honestly. I did my absolute best to complete all the portions of the exam under very difficult circumstances. And I was truly surprised when I saw my score. It left me with a strong impression that my score may not been adjusted at all using the psychometric method. Initially, I believed I understood that method based on the bar's motion submitted to the Supreme Court. But now, considering the specific problems I faced at the testing center in Glendale, I no longer believe my results were properly adjusted in the way described in that motion. I invested months of intensive preparation, significant financial resources, and most importantly, I made personal sacrifices. I have 3 children, and during this time, I was out of the legal practice that created real financial difficulties for me and for my family. I'm now respectfully asking the board to consider recommending the granting of a provisional license. This would allow us to begin working in California, support our families, and start covering the debts we have continuously incurred. Thank you for your time and consideration.
Thank you. Next, we have Aysel Askarova. I do not see that person in attendance. Next, we have phone number ending in 1712. I do not see that person in attendance. Next, we have Luke. Luke, your microphone has been enabled. Your microphone has been enabled. You just need to unmute yourself. Okay, we'll move on. Next, we have Douglas Sanger. I do not see that person in attendance. Next, we have Ilana. Ilana, your microphone has been enabled.
Good morning. Can you hear me?
Yes, thank you.
Good morning. I took the February 2025 California bar and received a score of 1385.5, just 4.5 points below passing. I earned a 1405 on the written portion, which I believe shows I have the legal skills this exam is meant to test. As we all know, some examinees who didn't start or complete parts of the written portion were granted and passed. Yet candidates like me who completed the exam despite serious disruptions were not given the same consideration. During my performance test, I lost around 15 minutes because I couldn't open the library and my proctor was unable to pause the timer. On the second day, the testing software repeatedly kicked me out, and in the afternoon session, I had to wait over 30 minutes just to get back without knowing if I saved my response. The Kaplan section also included unclear AI-generated questions that didn't reflect what we were trained to expect. One of my essays was downgraded after second read, which only adds to the feeling that this exam was not consistent or fair. We didn't fail the bar failed us. I respectfully ask that the board consider granting passing scores to candidates within a few points of the cutoff, especially those like me who passed the written portion and received the second read. It would be an act of fairness, not exception, and an acknowledgement that this administration was not standard. Thank you so much. Please, we urge, please consider the remedies to consider these people who were so close of passing, and because of all the issues that we encountered, we were not able to pass, only for a few points. Thank you so much.
Thank you. Next, we have Zach the Facio. Your microphone has been enabled.
Good morning. My name is Zach DeFazio Farrell. I'm a February 2025 bar exam applicant. I passed the exam, although I'm not sure at which point exactly I crossed the Rubicon from incompetency to minimum competency. But I am speaking today for those who should have passed alongside me, if not for a fundamentally broken process. So we paid thousands of dollars, gave up months of our lives, and expected to be tested on our legal competence. Instead, we got system crashes, lost work, proctor interference, and AI-generated questions that were never disclosed, some outside the test content. Then, the same vendor that helped write those flawed questions was allowed to grade them. It's a clear conflict of interest. Even the Supreme Court stepped in, ordering a return to NCBE authored questions. If this exam wasn't trustworthy enough for July, why are February's results still being treated as valid? The State Bar claims its mission is to protect the public and expand access to justice. But how does this ordeal protect anyone? Using imputed scores based on guesswork doesn't protect the public. Forcing thousands of applicants, denied a fair test, to retake it at their own cost and risk doesn't expand access to justice. Clinging to a single, dubious measure of competence while ignoring effective alternative pathways used in other states is not public protection. It is institutional dogma. We need to ask, what is the purpose of the State Bar if it is actively undermining its mission? Between financial mismanagement, the years-long backlog of attorney discipline cases, and now this exam debacle, is the bar truly protecting the public, or is it gatekeeping the profession to preserve its own authority? We're not asking to bypass competence. We're asking to demonstrate it in the real world through a supervised provisional licensure program without being forced to re-enter a flawed and demoralizing exam process. And attorney applicants already proven their fitness elsewhere should be granted admission on motion. Anything less continues. Let us serve our communities. Let us meet the needs of those who lack legal access.
So your time is up. Next, we have Jamie. Jamie F. Your microphone has been enabled. Hi, your microphone has been enabled. You just need to unmute yourself.
Good morning, and can you hear me?
Yes, thank you.
Good morning, and thank you for allowing me the opportunity to speak. I'm here to speak on 3.2. With each day more is revealed about how haste and rush this exam process is thrown together, I'm completely flabbergasted. What do you mean you didn't hire a copywriter to review and vet the questions before they were proposed for examination? Here today, I want to advocate to pass all of those who had a second read. It is staggering how there's a disparity upon going from first read to a 70, then going to a second read of a 55. Secondly, I would like to advocate for a provisional licensure for all unsuccessful applicants, possibly within 2 tiers. One, a pathway without retake for those over a certain score, and those for those underneath that score, a provisional licensure, but with a retake. And lastly, I would like to advocate to allow all attorneys all attorney applicants be admitted upon motion. Thank you.
Thank you. Next, we have Neri Lozano. Your microphone has been enabled.
Hello, can you hear me?
Yes, thank you.
Hi, I just want to thank everybody, the trustees, for being here. I almost didn't come because I'm at the point where hope is almost lost. That I'm trusting the institution that wants us to trust them has failed us. I was a part of the Reset series by Professor Basic that the State Bar hired her and Professor Schindler to do in January and February. And then when after the entire fiasco happened, she was blocked along with other professors from just viewing being part of the process to get adequate remedies. And this is just another reason of why I almost didn't call, because like many of the callers who have said that they experience all these issues, I also took the test with accommodations. I had incredible ordeals, days 2, 3, and 4, waiting over an hour when not only did the screen just burn out, and then after that the measured learning couldn't do anything. The State Bar was giving people a full refund 1 day before the bar, which is incredible. Just the remedies that I would like the trustees to take on would be the provisional license for those who got the second reading, for and also to get the 40 points that were given to people who took the tests, the questions that were written by Kaplan, who were generated by AI in the end. And please take this into consideration.
You apologize for your time is up. Next, we have someone with the phone number ending in 4439. That person's not in attendance. Next, we have Ashley R. Ashley, your microphone has been enabled.
Morning. I'm one of many applicants directly impacted by the February bar exam. I received a second read, meaning I was performing near the minimum competency threshold, even though I missed a whole multiple choice session. Yet without score imputation, as discussed but ultimately not implemented, applicants like me were denied a fair opportunity to succeed. The suggestion that this exam serves to protect the public is both misleading and deeply hurtful. In fact, I am a member of the public who has been harmed, not by an unlicensed candidate, by an actual licensed attorney. For context, in 2017, while working as a legal assistant, I was a pedestrian struck by a pickup truck outside the courthouse. My employer, a licensed attorney, not only failed to carry workers' compensation insurance, but concealed that fact until I filed a claim. When I reported my injuries, he made a rude remark saying that my bruises were just makeup. That comment was not only demeaning to me, but deeply disrespectful to my family who supported me through the pain and uncertainty that followed. He also delayed my pay, leaving me without groceries or stable housing. Despite these actions, he remains licensed to practice law. That is more harmful than us requesting a provisional license. After so many years of persistence, I demonstrated moral character, nearly passing an exam administered under deeply flawed conditions, and you're telling me I'm a threat to the public because I missed 13 points. But where was the protection for me, a vulnerable worker and a member of the public who was harmed under the supervision of a licensed attorney? That the state bar has no right to claim the bar exam protects the public when it failed to protect me long before I ever sat for it. If you truly believe this exam serves that purpose, then the state bar should
We
recommend the
apologize for your
Supreme Court
time
to
is
waive
up.
your immunity.
Next, we have Andrew Omana. One moment. Andrew Omana, your microphone has been enabled.
Can you hear me?
Yes, thank you.
Hi, my name is Andrew Romana. I took the February 2025 bar exam remotely. I had multiple disconnections the first day with the essays. My exam lasted for 10 hours because of the disconnections and switched between 15 proctors. However, I was able to finish the essays and I failed the bar exam for 13 points. What I see is that the second grading lowered their scores like without reason, and I would like the bar to have an investigation or to respond if the grading of the essays was done with AI or real people, because it seems completely weird. The second point is that on the multiple choice, I took the experimental bar in November. I didn't see anything on my scores about the scores if we got anything from the November experimental bar. And another, to be on the fair side, just as everybody said that if somebody got a second reading, they should be considered passed. But another remedy would be, because we all had issues with Kaplan multiple choice questions, let us take the July multiple choice questions only and show you that we are competent. And we studied for the bar. I took time off work without pay, and I was prepared for this bar, and I believe I passed. So I urge the bar committee and the trustees to implement these remedies, because it's such a shame that we are trying so hard. For me, it's the third time taking the bar and not passing because of not our fault. Thank you.
Thank you. Next, we have Susanna. Susanna's not in attendance. Next, we have Navi. Navi is also not in attendance. Chair Stallings, that does conclude all of our advanced signups. So we can move on to remote attendees with our hand raised.
Yes, please.
First, we have David Green. Your microphone has been enabled.
Hi, yeah, my name is David. I propose a remedy that applicants that failed the February bar exam should be automatically allocated 50 to 100 points for the next bar exam that they sit for. It wouldn't cost the bar any money, and they've allocated points for previous mock exams in the past. Thank you.
Thank you. Next, we have Henry.
Good morning. Good morning. My name is Henry Marini. I am writing yet again to this board to inform you about the corrupt actions of Los Angeles City Attorney Heidi Feldstein Soto. I beat my case against Heidi, and it was pretty clear through the discovery obtained, as well as the admission of Ethan Green, the trial counselor at hand, who openly agreed that the case was utterly frivolous, but it doesn't end there. I actually confronted Heidi in public, and I recorded her admitting that she knew that my case was utterly meritless, that she took it as a political good faith gesture to aid the cult of Scientology, to further aid and abet their corrupt actions. And I just want this board to know that I will at one point in the future become a licensed attorney in California, and I will be coming after the city for the damages they've done to me. And if this board doesn't act, I will come after this board for not prosecuting Heidi. This now makes 3 high public profile cases where Heidi has maliciously prosecuted people. There's Michelle McGinnis, there's Richie Sergienko, and there's myself. All publicly admitted of utterly baseless claims, and she does it for the political goodwill of her donors. And again, I have her on recording where she, for some reason, knew my name but couldn't make out who I was by my face. And I just asked her about myself. I asked her about my case. And she openly admitted that she knew the case was frivolous, yet she prosecuted it for an entire year, nearly the statute of limitations for a bogus 1-count misdemeanor vandalism that was ultimately dropped and dismissed. No fines, no criminal convictions, no criminal history, gone. I won. This is what Heidi Feldstein Soto's legacy is, colluding with Scientology to commit lawfare and harass protesters. Thank you.
Apologize for your time. It's up. Next, we have Dean Pritnick. Your microphone has been enabled.
Hi, can you hear me?
Yes, thank you.
Hi, Martin Pritikin, Dean of Purdue Global Law School. The CBE has recommended that the Supreme Court renew the provisional licensure program that was rolled out in the wake of COVID, so that this cohort of bar takers or would-be bar takers would have 2 years to practice under the supervision of a licensed attorney before they would need to pass the bar exam. I strongly urge the board to go one step further and recommend that the Supreme Court adopt a pathway to licensure program by which law school graduates who satisfactorily practice under the supervision of a licensed attorney can earn licensure without having to go back and sit for another bar exam. Common sense suggests that how someone performs as a practicing attorney is a much better indication of how they will perform as a practicing attorney than how they performed on a 2-day standardized written exam. But the board need not rely just on common sense. The evidence from the post-COVID provisional licensure program was that not only weren't there higher rates of ethical violations by provisional licensure participants than for licensed attorneys, there wasn't even a higher rate of complaints of ethical violations. So there's no reason in logic or experience to make someone who has satisfactorily practiced for hundreds of hours under the supervision of a licensed attorney to go back many months or even years after they graduated from law school and take a bar exam that requires recall of voluminous amounts of doctrine that is faded from their memories, especially when the exam has never actually been validated as a measure of minimum competence. The Blue Ribbon Commission recommended the Supreme Court adopt a supervised practice pathway, and the court previously declined to adopt it. However, it's clear that options that were previously off the table are now in play. The court has already ordered that the July exam be administered using the MBE, which no one had contemplated prior to February's disaster. If the board recommends a practice pathway now, the court may be receptive. They say every challenge is an opportunity. The February debacle provides a terrific opportunity for a natural experiment to run a supervised practice pathway pilot program. There may never be a better opportunity to try something like this. It's safe for consumers and is the right thing to do by bar takers. Thank you.
Thank you. Next, we have Bryce Woolley. Your microphone has been enabled.
Thank you very much. Can you hear me?
Yes, thank you.
All right. Thank you, Louisa, Board of Trustees, and everybody who has commented so far. My name is Bryce Woolley, and I'm an associate professor of law for academic success and bar preparation at Southwestern Law School. I am speaking in support of the reciprocity remedy as it relates to agenda item 3.2, non-scoring remediation measures. Pardon. Some applicants were unable to submit enough essays to qualify for the score adjustment due to severe technical difficulties, which have been thoroughly described in this and previous Board of Trustees meetings. This includes applicants with long-standing and illustrious legal careers in other jurisdictions. For example, an applicant I know experienced severe technical difficulties, including a 3-hour delay to start and inability to submit numerous essays. This applicant has been a practicing attorney in another jurisdiction for 35 years. 35 years. I expect many other attorney applicants are in the same situation. I have heard expressed at previous meetings a concern that any remedies would endanger the California public by admitting incompetent attorneys. This concern, while valid, is completely irrelevant to licensed attorneys that have successfully, competently, and ethically practiced in other jurisdictions for decades. Decades. Should the reciprocity remedy be limited to be more palatable, a minimum practice years could be a requirement. The requirement for the attorney's examination is 4 years in good standing. In this unprecedented situation, a reciprocity remedy is clearly appropriate in cases of attorneys licensed in other jurisdictions that have practiced for decades. I respectfully request you implement an appropriate reciprocity remedy. Thank you.
Next, we have Noah Sachet. Your microphone has been enabled.
Hi there, can you hear me?
Yes, thank you.
Hello, members of the board. I'm here today not as a lawyer, but as a close friend of someone who sat for the February bar exam and someone who believes deeply in fairness, accountability, and justice. My friend is a law school graduate from an accredited institution. She moved to California recently with her 2 young children, both under the age of 5. This was her second attempt at the bar exam. Her first was in July. And what she endured during the most recent sitting was not only unfair, but deeply troubling. While I may not hold a JD, I know what justice looks like, and what she experienced was the opposite. There were technical failures during her exam. Basic functions of the test software did not work. She was not granted the full time she was entitled to. These are not minor inconveniences. They are structural barriers that call the validity of the exam into question. Let me be clear, no one is asking for a handout. These candidates are asking for what they have earned, a fair opportunity to demonstrate their competence. Instead, they were met with a deeply flawed process that undermined their chances and their futures. My friend cannot afford to wait another 6 months to find out if she passed, and then possibly another 6 months or longer to find employment. She, like many others, has responsibilities, a family, and a future on hold. We all agree the bar should assess competence, but this was not a competent process. This was a failed experiment. Administrative and technical failures have caused real harm. To allow this to continue without immediate and transparent corrective action would be to punish the test takers for the mistakes of the system. That is not justice, that is negligence. This situation has gained national attention for a reason. People are watching, and those of us who care about fairness are expecting this board to act with the utmost urgency. I respectfully ask the board to do the following. Pass the test takers who received a second read, recognizing that the scoring process itself has been compromised. Award additional points to those who were not given their full legally allotted time to compensate for that lost opportunity. And for all other February 2025 exam takers, offer provisional licensure, allowing them to work and support their families.
Next, we have Esther L. Your microphone has been enabled.
The State Bar of California allows for examinees to petition their scores on the basis of clerical or administrative error. At least for me, if not everyone else speaking here, the administration of the multiple choice examination, both in execution and in the writing of questions, is an administrative error. As documentary evidence of this, I need not look any further than to the fact that this State Bar has filed a lawsuit against ProctorU, the administrators of that exam. Even more so, not only had the deans of multiple ABA-accredited law schools expressed concern with Kaplan's multiple choice examination due to typos and nonsensical questions, but the California Supreme Court ordered that the State Bar's examination can no longer use ProctorU or Kaplan's services. As multiple parties, including this State Bar, agree that the administration of the multiple choice portion of this exam has been flawed on multiple fronts, then how is it fair to fail us on the basis of that failed exam administration? If you take my first read raw score of 440 multiplied by the factor used to calculate my combined scaled written score, it would be a 1408, a passing score. The raw score of 475 for my second read alone is a scaled score of 1520, another passing score. If averaged with my multiple choice score of 1300, would have combined to a scaled score of 1410, a passing score. I passed this exam in the portions not ruined by calculation of objectively faulty questions. I am minimally competent, and it would be an administrative failing to keep me from being an attorney on these grounds when I received a second read on my examination. Despite these failings, I was only 7.5 points away from passing. I believe many of my peers feel the same, which is why the agenda item regarding reconsideration of examinees who had a second read on their essays should be highly considered. Thank you.
Thank you. Next, we have Vivian Lin. Your microphone has been enabled.
Hello, can you hear me?
Yes, thank you.
Great.
Good morning. My name is Vivian Lin, and I'm speaking as someone who witnessed firsthand the impact of the February 2025 bar exam, not as an attorney, but as someone who cares deeply about fairness and due process. A close friend of mine sat for that exam. What she went through should not be happening to anyone, especially not in a system designed to measure legal competence. This was her second attempt at the bar, and instead of being given a fair shot, she encountered a cascade of problems. Her test software malfunctioned, she wasn't given the full amount of time she was owed, and she was left uncertain and unsupported throughout the process. You don't need to be a lawyer to know when something is unjust. What happened to her and to so many others was a failure not of the test takers, but of the system itself. This isn't about cutting corners. It's about correcting a breakdown in a process that is supposed to be reliable and equitable. The reality is that many of these examinees are under enormous pressure. They spent years studying, investing in their careers, and making sacrifices. They do not have the luxury of waiting another 6 months to retest and then potentially even longer to secure employment. There's no question that the bar should test for competence, but the February exam did not do that. Instead, it subjected the test takers to shocking technical and administrative failures. The people who sat for that test shouldn't have to carry the consequences of those errors. This is bigger than one individual. It's a matter of public trust, and right now that trust is fractured. So here's what I urge the board to do. 1, grant a passing score to candidates whose exams required a second read, recognizing the lack of consistency and fairness in scoring. 2, award additional points to those who were not given their full legally allotted time to compensate for that lost opportunity. And 3, provide provisional licensure for the rest of the February cohort so that they can begin working while this is sorted out. These aren't demands for leniency. These are necessary steps to restore fairness and integrity to the process. Thank you.
Thank you. Next, we have Andrew Shaver. Your microphone has been enabled.
Good morning. By way of introduction, I earned my PhD from Public Affairs from Princeton University School of Public and International Affairs and am a professor in the social sciences who works extensively with data. I'm offering comments on agenda item 3.2 in a personal capacity as the husband of a bar taker. While the bar 2025 exam may have been unprecedented in the history of the exams administration, the data problems it poses are not unlike other scenarios that empirical social scientists consider in other settings. My focus is on the choice to offer a blanket point adjustment, how that can affect different populations of the exam takers, and likely resulting negative externalities. I propose the following analytical framework which relates to the phenomenon of regression to the mean for thinking about the exam difficulties and subsequent blanket point adjustment. First, consider such difficulties as effectively random. That is, whether an exam taker experienced computer issues and how extensively those issues were, from not allowing copy and paste functionality to the number of times our computer crashed, to whether copy and paste functionality impacted 1, 2, 3, or even all essay questions was a matter of bad luck. The difference of sitting at computer number 281 versus 280 at a given testing center. Assume further that exam takers' would-be scores were differentially impacted by varying numbers of points that either exceeded, equaled, or fell below the blanket point adjustment. This would result in 4 outcomes. Number 1, passing passers, individuals who passed with scoring adjustment and would have passed otherwise. Passing non-passers, passed with adjustment but would not have passed in the absence of problems. Non-passing passers did not pass with adjustment but would have passed in the absence of problems. And 4, non-passing non-passers. Outcomes 2 and 3 are negative externalities. Without additional data, it is impossible to determine exactly how large each of these populations is. However, it can be reasonably inferred from the data generating processes that both externalities would have occurred to some degree. The public comments offered today clearly communicate significant technical challenges. Many of these individuals plausibly fall into the set of non-passing passers, and remedial actions taken so far would offer no specific redress for this population. The statistical method of simulation can be used to model how extensive these resulting externalities may be. We're outside impartial professors of statistics afforded access to additional exam information by the relevant authorities. They might simulate very possible scenarios that have occurred.
Apologize, your time is up. Next, we have Amber. Your microphone has been enabled.
Hi, can you hear me?
Yes, thank you.
Yes, good morning. I urge the board to automatically admit bar applicants who received a second read on the February 2025 California bar exam. I am one such applicant. I received a total score of 1386, just 4 points shy of the passing threshold, despite persevering through the widespread adversity that disrupted this exam cycle. If the same psychometric imputation used for applicants who were not able to finish had been applied to my scores, it is likely that I would have surpassed the passing mark. As it stands, it appears that students such as myself were inadvertently penalized for completing the exam through challenging circumstances. Furthermore, given that some of the exam questions were reportedly generated by artificial intelligence, it remains unclear how second read graders evaluated those essays without transparency in the grading process, particularly when the content and origin of the questions themselves are in question. Applicants like me are left with unresolved concerns about fairness and consistency. Additionally, the post-exam score adjustments, which were approved by the Supreme Court and it appears to be implemented over the span of just 2 days, raise reasonable concerns about the potential for miscalculations, clerical errors, or inconsistencies in implementation. These risks are particularly relevant for applicants whose scores were manually reevaluated during the second read process. While thousands of applicants reportedly received score adjustments, it remains unclear whether the same remedial approach was applied to second read applicants. Finally, it must be emphasized that those of us who were neither unaware nor given the opportunity to take the experimental exam in 2024, which was an opportunity that could have allowed us to gain extra points. And given these factors, I respectfully urge the board to take meaningful action and grant admission to second read.
Thank you. Next, we have Nina Anchetta. Your microphone has been enabled.
Hello, can you hear me?
Yes, thank you.
Hi, I am here to petition passing people who got a second read. I am one of those people who got a second read and I was pretty close to passing, 19 points away. However, because of all the technical difficulties that occurred and also the amount of distraction, it affected how I performed. If none of these happened, I think I would have performed better. So the first thing I want to talk about is the performance test. I experienced the same exact thing as the people here have said with the copy and paste and the constant lagging. And waiting for the proctor to help me out while my time was running. So one thing that I also would like to add to the complaint is that I heard that other remote takers were able to have the copy and paste option for the first 30 to 40 minutes or the entire time. And that to me, I feel like we're not playing in an equal playing field. Even though I scored a 65 on the performance test, I still felt like I could have done better because there were things that I had to sacrifice not adding into it. That's the first thing I want to add. Second, there was also a lot of lagging on the essay portion and the multiple choice, which affected my flow of thoughts. And also the distractions during the exam. We all didn't start the exam at the same time. The proctor said that if you log in, you start. And that greatly affected probably not just me, but a lot of people's concentration, especially during the multiple choice, because you could see people leaving and like busting the gates super loud. And yeah, I just want to bring that up. Thank you.
Thank you. Next, we have Benjamin Cohn. Devin, just as a reminder, Mr. Cohn gets 3 minutes. Thank you.
Thank you. I wanted to first bring to your attention a new issue or that may already be on staff's radar because they follow Reddit and Facebook forums. But as you may recall, some of the test takers had reported that some measure learning proctors had shown them other examinees' answers during all the tech troubleshooting that some proctors, I guess, had a way to mismatch those things, and it occurred either due to ignorance or glitch. And it appears that now some applicants are reporting that now that they have their exam results and their purported answer files, that they don't recognize any of the essays that were in their answer files at all, and it appears clear to these applicants that someone else's answers were attributed to them and submitted under their name, and their exams may have been graded for the benefit of somebody else due to a similar issue. And it's not just like an isolated number of reports. There were those same original consistent reports of proctors showing them other people's answers and stuff like that at the beginning. And now there's on multiple social media forums and multiple applicants reporting that this happened to them. So it appears that some people may not have even gotten the benefit of being graded on their own work for their exam results. And that needs to be remedied. I know Measure is now refusing to give you certain data of certain tech glitches, but maybe you can get an injunction that's more urgent regarding that. Second, that leads me to my next point. I really do want to commend and praise the State Bar and the board for authorizing this lawsuit against Measure Learning. As you know, I'm usually against you on litigation positions, but in this instance, I am going to be able to root for my opposing counsel on this case, and that is nice to see. The third point I wanted to make is that the results, despite the high pass rate, that doesn't mean that people who would have passed did pass. That it just means that there was a lot of one-size-fits-all boosts that will help some people, but not be proportional to the types of issues suffered by others. And so that high pass rate does not mean that this is harmless, that it's harmless to not provide more than provisional licensure. You need to provide someone a way not to retake.
Apologize, your time is up. Next, we have Mary Basic. Your microphone has been enabled.
Hello. I know you all must be interested in getting public trust restored and the integrity of the State Bar. And I have some suggestions that I'm hoping will go towards that. As you know, the score sheets were released to applicants approximately 2 days ago. And in reviewing those score sheets, I have some observations. So one, I recommend that you reassess scores for those who had scoring irregularities and perhaps do some imputation. So we are seeing score sheets where people who otherwise are doing good written work are getting scores of zeros, 40s, 45s on those PTs. Those have to be a result of the problems with the exam itself. So those should be either imputed or taken out of the equation and scored without. Also, you can check for people who were supposed to have an accommodation and didn't get it and impute some scores for those folks. I recommend you release the written rubrics and grading guidelines. The CBE chair said that you use normal grading rubric and guidelines. Let's release them. I am seeing score sheets where people are getting a first read score of a 65 and a second read score of a 45 on the PT. That would be akin to getting an A on one and an F with the other person looking on it. That's an indefensible score. I recommend you release all 200 Kaplan questions and the data with those. The executive director has expressed her confidence in Kaplan, but at no point has anybody from the State Bar acknowledged the information that Professor Moran and I have provided about all of the problems with the Kaplan questions, the irregularities, the wrong law, and that they have added content. I also recommend a just one other thing, the scores. We're seeing people on some of those MBE scores where the same person is in the 4th percentile on one subject and the 95th on another. That's bizarre. Partial retake, that's an excellent option and it will make it easier for people to prepare for the bar.
Thank you. Next, we have Brenda Mendez. Your microphone has been enabled.
Hi, can everyone hear me?
Yes, thank you.
I just want to say score reputations for those with tech issues is a step in the right direction, but it is not enough. Taking out some of the multiple choice is not enough. I failed by just 7 points just because of the new MBEs. That's just a couple of MBEs that I missed because of the new Kaplan questions. What if you let us just retake the MBE sections? That way we don't have to put all of our lives on hold. The Senate themselves just told the State Bar this week that the bar exam just tests to see if you can be a sheep. Those are the Senate's words, not mine. Please let us complete hours of supervised legal service. In 2021, California granted admission to those who narrowly failed under similar circumstances. Please do this again now. I want to break down how much money I am losing because of this. I lost $17,500 to take the bar in February, $1,000 for the bar, $1,000 for the Airbnb, $3,500 in bar prep, $12,000 in lost income for my 3 months off. And now I'm going to have to retake it again just by missing a couple MBE questions. You know how much more I'm going to miss because of that? $29,500. $3,500 for bar prep, $2,000 to retake, fly to a location, get my Airbnb, $12,000 in lost income for 3 months, an additional $6,000 I would have made with an attorney salary. Then I wouldn't be making attorney salary until December, so that's another $6,000. That's $47,000 that you guys are robbing me of. Please, if we come to a second read and we're close enough, even by a couple points, please let us pass. Please let us redo just the MBE question so I don't have to take a whole 3 months off again. I'm not alone. There's a lot of people that would have to retake 3 months off again for all of this. That's $47,000 that you guys are robbing me of. Not only me, but a lot of my fellow test takers. I've demonstrated minimum competency. We're ready to work. Let us get on with our lives. Let us feed our family. Let us provide for ourselves, please. Our life is just on hold because of this. Please find it in your heart to do the right thing and help us. Thank you.
Thank you. Next, we have Andrew Lerner. Your microphone has been enabled.
Hello, can you hear me?
Yes, thank you.
Hi, I'm a licensed California attorney. I've been practicing law since 2008 and passed the bar exam in 2018. I would like to address on section 3.2 some of the inconsistencies and problems that I've found in the February 2025 bar examination through my conversations with people who have taken the exam, professors who work at certain universities and law schools, and the general public as it pertains to the flaws that were flagrant as we see them, especially in the performance test. So I want to speak specifically to the performance test, speaking specifically to the lack of the copy and paste function, and rendering the performance test more or less, as been described previously, a memorization test versus a test for minimum competency and legal knowledge and capacity. I believe that a suitable outcome or remedy would be to impute a score higher than those that were given to test takers who were unable to competently complete the performance test, in light of the fact that test takers who were who did not submit anything at all or who left the answer blank were given a higher test score than people who worked very hard to try and provide an answer only to be penalized by their lack of providing a full and complete answer. I obviously see a disparity in the logic between giving somebody a higher score who basically quit on the test and wrote nothing versus somebody who persevered, followed through, and then got a score that was reflective of misallotted time or certain incapacities with the bar exam. So for those reasons, I would like the board to seriously consider the harm that was imputed and try and make adequate remedies for those who suffered. Thank you.
Next, we have Nathaniel Metzger. Your microphone has been enabled. Hi, your microphone.
Thank you. My name is actually Katharina Allen Flagg. I'm the third time test taker, February 2025, and I am advocating for licensure for the second read candidates. This is my third time, and I've improved from my first time. I prepared very hard. It took me 4 months. I was camped in my living room. I did not even sleep in my bedroom, preparing for this exam. So I was very confident. However, the CalBar has failed us miserably. It says that you are supposed to be protecting the public. we are also a member of the public. And the California Cal Bar has a moral responsibility to correct this, because the one-size-fits-all does not work for everybody. It certainly does not work for me. I had so many issues. I had 5 proctors trying to get me to start the exam. Understandably, I'm at my wit's end, to the point where one of the proctors says, "Miss, you really need to calm down." And I gathered myself. I did the best that I could. I came within I received a second read. That is because I came close enough. I started the exam 25 minutes late. One of my grades was 70, and the first reading was 70, the second reading was 50. What accounts for that spread? It's the same information, okay? And that caused me to not have enough points. Okay, so the systemic failures with the PT cannot be overstated. And I analogize it like a surgeon doing a microscope.
I do apologize, but your time is up. Next, we have Amira Muhammad. Your microphone has been enabled.
Dear trustees, the State Bar failed to give us a remedy for those of us who were supposed to have been granted accommodations. No one wants to be disabled, but some of us are. My disabilities require me to type, my disabilities requires more time for me to type. Without this additional time, I cannot compete with other test takers who have full mobility in their hands. Many of us who the bar granted accommodations did not receive them. If I would have known that I was not going to be able to receive my federal approved accommodations, I would have never taken this exam. I understand that no one knew of these horrible causes that were going to take place. But trustees, please, please correct this wrong and make it right. I hear so many people today saying, please give the second readers another chance. But do you understand that giving those who did not get their accommodations, they didn't get a second read? I was always taught to never leave any questions unanswered. After losing 20 and 30 minutes at a time, I saw the clock said 5 minutes left, so I began to check off what I could. Those that left everything blank passed the bar. I didn't. My essays reflected scores in the 70s and 65s, except the PT. And I won't repeat all the problems that everybody had with the PT. I suffered excruciating pain in my hand, but I wrote every essay. Yet those who wrote no essays.
I do apologize, but your time is up. Next, we have Sal Saperstein. Your microphone has been enabled.
Good morning, can you hear me?
Yes, thank you.
Great. My name is Sal Saperstein, and I sat for the February 2025 California bar exam. Let me be clear. This exam was an unprecedented disaster, an administrative and technical failure of historic proportions. And yet, the remedy offered, a 55% pass rate and a blanket scoring adjustment, is not only insufficient, it's logically and morally inconsistent with how this very board handled the July 2021 exam. In 2021, the bar verified individual disruptions and adjusted scores accordingly. In 2025, you applied a one-size-fits-all imputation only if someone left a section blank. That turned the bar exam into real-time roulette. If you fought through tech issues and did your best, like the bar tells us to do, you got punished. But if you left a section blank, jackpot. Score imputation for you. That's not fairness. That's hogwash. And here's the kicker. We couldn't even document the issues in real time without risking a Chapter 6 violation. You put examinees in an impossible position. Either roll the dice on a future remedy or try to finish under duress and hope for justice that never came. A 55% pass rate might look like lipstick, but this exam was a pig, and everyone here knows it. You've only helped those who happen to fall within your arbitrarily defined subset. The rest of us, we did what we were taught, to put our best foot forward while the floor collapsed beneath us. But let's continue to talk about fairness. How is it acceptable that someone with a disability or approved accommodations like myself was still blindsided by software failures and proctoring chaos in violation of the ADA? Far too many of us were denied the accommodations that you guaranteed us, and no one has provided a sufficient response as to how it wasn't a conflict of interest to allow your psychometrician to draft questions for the exam and then assess their own validity. That's a joke. You know what else is a joke? I scored 70 on the crim law essay, but somehow I placed in the first percentile on the multiple choice for that same subject. My infant nephew could literally do better than that. Same with contracts. There are tons of similar instances to mine. What is going on here? Could that have something to do with the AI-generated questions you slipped in? If so, where is the accountability? Where is the accountability? There is no one saying, again, at 55 pass rate.
Your time is up. Next, we have JM. Your microphone has been enabled.
Hi, can you hear me?
Yes, thank you.
Hi. So my name is Julie, and I am also a February 2025 test taker. And like so many others, I can't even go into it. I know you guys all know what happened with my screen with no additional time given to me. People screaming behind me at proctors with copy and paste functioning not working. Poor people crying around me. It was chaotic. I'm urging the state bar to allow those who qualified for a second read to be deemed as having passed this exam. We already demonstrated minimum competence. You argue that your role is to protect the public, but the people who reached the threshold for a second read have proven that they are capable. They are right on the cusp, and many of us were held back not by lack of legal knowledge, but by the circumstances beyond our control. Please help us. We aren't asking for shortcuts. We just want fairness. Thank you.
Thank you. Chair Stallings.
All right, the time is now 11:07 a.m. Public comment started at 9:07, so pursuant to board policy of public commenting lasting for 2 hours, that is with us not taking any break during that, I will now close the public comment period. And Madam Secretary, approximately how many people did we hear from?
About 58.
Okay. All right, thank you all for your comments on this very important area. All right, so since we've been going since a little after 9, yes, Trustee Sewell.
I just also wanted to ask Louisa whether or not, do we know how many more folks we might have had in the queue?
Yes, we have about 62 additional or 63 additional speakers. Or that number keeps going up, Trustee Sewell, 67 at the moment.
Okay, thank you.
You know, and I think certainly we would like to hear from everybody, but we do need, as a body, to deliberate on these issues, and so we're sorry that we cannot get to every single commenter. We have been going since around 9 o'clock, so let's take a break. Is everybody okay coming back at 11:20? Gives us a little over 10 minutes. That work? All right. Okay, we'll take a brief bio break. See everybody back at 11:20.
Recording. Okay, we're now recording. Chair Stallings.
Thank you, and welcome back to today's board meeting, February 9th, 2025, back from a short recess. Before I go into my chair's report, Madam Secretary wanted to turn it over to you for an introduction.
Yes, thank you so much, Chair Stallings and trustees. I know many of you have already met Devin McFarland, but I just wanted to briefly reintroduce her. Devin is a program analyst in the Office of Admissions and has been with the State Bar since 2017, starting in State Bar Court before moving to admissions in 2020. She serves as the committee coordinator for the Committee of Bar Examiners and supports the Chief of Admissions, and also works very closely with Sharon Lim, which many of you have not met Sharon Lim before. She's a principal program analyst, also in the Office of Admissions. Sharon started at the State Bar in 2020 in judicial evaluations, supporting the Jenny Commission, and recently transitioned into her current role, supporting the Chief of Admissions. Both Sharon and Devin are Bay Area natives and graduated. Sharon graduated from San Francisco State with a degree in journalism. Both Devin and Sharon are training closely with me as part of the transition of responsibilities, and you'll be seeing more of them in the coming weeks as they step into board operations and support. We're lucky to have them on board, and I know they'll do a great job.
All right, thank you so much for being here in attendance and for all you do to assist Louisa. Also joined by Erica Doherty, our Deputy Executive Director, and many other staff who make these meetings work. So thank you all for your work to get these meetings up and running. As a portion of my chair's report, I would like to introduce Ryan Harrison. He is our most recent appointee to the Board of Trustees. He was appointed by the Supreme Court, and I wanted to turn it over to him to tell you just a little bit about his State Bar experience, because he brings an enormous amount of experience with various issues that we touch on. So welcome, Trustee Harrison.
Thank you, Chair Stallings. It's an honor to be on this board. I am ready to get to work and to deal with these issues, particularly this February 2025 bar exam issue. I've served in several capacities with the State Bar, first through the Council on Access and Fairness, where I spent 4 years and finished as the chair of the sub-entity. The Supreme Court also appointed me to the Blue Ribbon Commission on the Future of the California Bar Exam, where we spent about 2 years working on that. I also am the former president of the African American Bar Association of Sacramento County and board member for the California Association of Black Lawyers. And I had to leave the Commission on Access to Justice because of my appointment to this board, but I have served on the California Commission on Access to Justice, and I'm just happy to be here, and I am ready and prepared to do good work to remediate these issues. Thank you.
All right, thank you, Trustee Harrison. Trustee Harrison, as well as Executive Director Leah Wilson, Program Chief Donna Hershkowitz, myself, Committee of Bar Examiner Alex Chan, and George Cardona all appeared in Sacramento on this past Tuesday, where we had the opportunity to address the Senate Judiciary Committee, where we were able to update the Judiciary. I'm sorry. Update the Judiciary Committee about efforts that are being undertaken by the State Bar to investigate the February 2025 bar exam, and welcome the Senate's bill, which calls for a independent audit of the February 2025 bar exam. We continue to incorporate the lessons that we've learned through the administration, and are doing everything we can to ensure that as smooth as possible administration of the July 2025 bar exam. We understand that major missteps related to the February bar exam have severely impacted many applicants, the individuals who have taken time out of their day to day, and who understand have also lost significant public comment with the Committee of Bar Examiners. And we're taking we've made steps to try and make it right, and today we will continue to address those issues and ways to make things right. I think that we have a pretty full agenda, so I will not say any more on that. We will go to our consent calendar. And then, I'm sorry, Louisa, is this the item that was being taken off?
Yes, that's correct.
Okay. All right, so there's only one item then on 2.1, so we will table that. We'll move then to item 3. This is item 3.1. This is an admissions update and discussion and possible adoption of recommendation to extend fee waivers for test takers impacted by the February 2025 exam through 2026. And this item is being presented by Chief of Admissions, Dawn Hershkowitz. All right, welcome, Ms. Hershkowitz and Ms. Ching.
Good morning. I'm going to share my screen. I'm sorry, let me just put this in the right mode here. Good morning.
Morning.
My plan today is to just give you an update from the Office of Admissions, talk about some activities that have happened since we last got together on April 2nd as the full board heard an update. And also as part of this item, requesting the board's action on extension of time to use a fee waiver for the test takers from February 2025 and those who withdrew from the February 2025 exam that the board had previously granted for the July exam. We'll be asking to extend that to additional exams as well for those who are not able to sit for the July exam for one reason or another. So starting with an update on the February 2025 exam, I'm sure the board is fully aware of the significant occurrences that have happened since our last discussion of the bar exam at the board's last meeting on April the 2nd. But to level set, and also for the public, and in response to some of the public comment today, I wanted to step you through some of what's happened since I last provided you an update. As you see here on this slide, on April 18th, the Committee of Bar Examiners developed recommendations for the Supreme Court on scoring related adjustments for the February 2025 exam, as well as to set the minimum raw passing score for this exam, an activity that they needed to do because we were no longer using the multiple choice questions provided by the National Conference of Bar Examiners, which previously had been used as the anchor for setting the scores. So I'm going to go into this a little bit more detail than I planned in light of some of the public comment, just to make sure everybody understands what was recommended by the Committee of Bar Examiners and what the Supreme Court ordered, which was largely consistent with the recommendations of the committee. First, let me talk about the minimum raw passing score. So the psychometrician recommended a minimum raw passing score of 560 points. That means that 560 points would translate to a passing or a scaled score of 1,390 points. And that's the pass line for the bar exam. That the 560 points that the psychometrician recommended was in fact a significant reduction from the recommendation of the standard validation panel. The standard validation panel looked at the multiple choice questions, and they looked at the essay questions, and they made an evaluation of what would a minimally competent applicant, what would they believe a minimally competent applicant would expect to get right, or how what would a minimally competent applicant for an essay or performance test, what would their essay or performance test look like? What kind of score would it get? That standard validation panel actually identified 627 raw points as what would translate to a 1390 passing score. Taking a look at a variety of factors, the psychometrician recommended lowering that to 560 raw points. The Committee of Bar Examiners was presented with this information from the psychometrician and from the standard validation panel. And the Committee of Bar Examiners was trying to figure out the best way to provide adjustments for applicants to account for the significant difficulties, technological, proctor-related, et cetera, the difficulties that you have all heard that people faced on the February exam. What they concluded and what they heard from the psychometrician was that the varied circumstances made it very difficult to identify, to categorize bar takers into these people. This group of people had a significant disruption, which should equate to an X point increase or adjustment. These people had a more minor disruption, which would equate to a different adjustment. Ultimately, the recommendation was that it would not be possible to individualize or even categorize into bigger groups test takers based on the types of disruption they had and how many points would be accounted for that. That went into the psychometrician's original recommendation of 560 raw points. The Committee of Bar Examiners felt that they really wanted to ensure that they were adjusting for, at least on a collective basis, adjusting for the difficulties, the significant difficulties that test takers faced. As a result, using a psychometrically valid approach, they reduced that 560 raw passing score to 534. The way that's broken down, as you can see on the screen, is 114 of the 171 multiple choice questions that were tested establishes a minimum raw passing score for multiple choice of 114 and also a minimum raw passing score of 420 out of a total possible 700 points on the essay and the performance test. Now, people could get a different mix of that. They could get lower on the multiple choice questions and higher on the essay or vice versa, and still meet that 1,390 passing score. So that was a big piece of what the committee did. Then they looked at individuals who were who had missing data, people who had some number of multiple choice questions for which there wasn't any answer, and also people who had essays or performance tests for which there was no answer recorded in the system. And what the psychometrician said and what the Committee of Bar Examiners concluded is that although this isn't a perfect remedy, that this was something that they could point to as a likely effect of the technological difficulties. So in addition to dealing with the collective effects with that 534 minimum raw passing score, they identified as a scoring adjustment that they recommended to the court that if somebody had no content in some of the multiple choice questions, or no content in an essay or performance test, but otherwise had completed 2/3 of the multiple choice questions or 2/3 of the written section, that they could impute a score based on a model called item response theory. And so that's what was done. And you heard a lot of public comment from folks who said, well, that doesn't seem fair to me. I struggled through the difficulties that I was having. I put down content and I was scored on my content. Other people were scored based on this psychometric model that may have ended up with them getting a higher score than I did when I really struggled through. And that obviously is one of the difficulties of choosing to do this imputation. Another one is that there may be people who, for example, if you had 2 multiple choice questions that you didn't answer over the course of the entire test, it may be because you didn't know the answer, you ran out of time and just simply didn't have time to get back to those questions. But the Committee of Bar Examiners felt that if you ran out of time, if you didn't have time to get back, if you put nothing in the essay or performance test, in the data and the anecdotal information would suggest that the reason for that was not because you simply gave up, but rather was because you experienced technological issues that impeded your ability. Maybe your clock ran down while you were talking to your proctor trying to fix something. And so they felt it was important to also provide for this imputation where there was no content, no answers for certain multiple choice questions or for the essay and performance test. The petition to the Supreme Court, which was submitted on April the 28th, expanded or interpreted this recommendation of the Committee of Bar Examiners to also include not just where there was missing data, but we had heard from some, and you've heard from some in public comment, where the test taker said they had absolutely no access to the file and library that are part of the performance test. Those of you who've taken the bar exam know that you cannot answer the performance test without the file and library. That is what you are supposed to be looking at. So, so we interpreted the CBE's recommendation for missing data when it came to the performance test to include those individuals who had no access to the file and library, but either because their proctor suggested it to them or because, as some test takers told you today, they've been trained to fill in an answer if they can. Some people did put words, so they had content. They didn't have missing data in their answer. And so the Supreme Court agreed and said that that imputation extends to those test takers who had no access to the file and library for the performance test. The Supreme Court also adopted the Committee of Bar Examiners' recommendation for the minimum raw passing score. And finally, the Supreme Court also directed that for the July 2025 in-person administration of the bar exam, that we use the multi-state bar examination multiple choice questions, which are developed by the National Conference of Bar Examiners. One other thing related to scoring that was done by the Committee of Bar Examiners at that April 18 meeting, but did not require action by the Supreme Court because the Supreme Court had previously delegated this to them. The Committee of Bar Examiners adopted what the scoring adjustment would be for those who met the minimum threshold of performance on the November special session, which was an opportunity to pre-test some of these questions. What the Committee of Bar Examiners adopted was that you met the minimum threshold if you got 28 of the 49 questions correct, and if so, you would have an adjustment of 40 points, 40 scaled points added to your multiple choice section, which when the whole formula is put together, ultimately that adds to it, that ends up with a overall 20-point scaled score adjustment to your your overall score. Of note, in addition to the issues with the administration of the exam and all of the technological challenges, which the board is quite aware, there's been a focus of late on the 3 separate sources that the multiple choice question portion of the exam were drawn from. So I wanted to go through these with you. For the 200 multiple choice questions that were tested, 117 were developed by Kaplan. 54 were from the unused bank of first-year law student exam questions, and 29 questions were developed by ACS Ventures, the psychometric firm that we are using, and they developed those questions using AI to formulate those questions. Similarly, on the November special session, there were 49 multiple choice questions. 35 of those were developed by Kaplan. 14 were developed by ACS Ventures, again, using ChatGPT, using AI to assist in the development of those questions. 11 of those 14 ACS questions were carried over to the February exam. So I want to just talk a little bit more about this. The contract that the State Bar has with Kaplan Exam Services did provide that questions from the first-year law student bank would be a source of material for the multiple choice questions. To be clear, these questions were not used to provide ideas for formulation of questions, but rather unused questions from the first-year law student exam bank of questions were incorporated in the question sets that went through our content validation panels, which I'll discuss in just a moment. But certainly most concerning for some was that 29 questions were developed in the first instance by ACS Ventures using artificial intelligence, specifically ChatGPT. The use of AI itself and whether it is or will be appropriate as a tool to assist in the generation of questions is a matter for a separate discussion that I'm certain the Committee of Bar Examiners and this board will involve themselves in the future. The issue, I think here, more than that, really was a complete failure in transparency. As the board has likely seen and heard, staff asked ACS Ventures to draft the questions because staff were concerned about not having sufficient questions in certain subject matter areas. There is a content map which identifies approximate proportion of questions which will be included in the multiple choice, and there were some areas where we did not have sufficient numbers of questions developed to meet those content map approximate proportions. So staff was concerned about that. Their intention was good, trying to make sure that we met the proportions of the content map. Their execution was horrible. This was a policy call that should have been escalated to leadership. It should have been escalated to the Committee of Bar Examiners, and it was not. It was something that should have been disclosed, but because of the breakdown in communications, leadership did not know that ACS was asked to develop questions by AI. What leadership did know was that to the extent that there was language in the Kaplan contract that provided strict limitations on how AI could be used if they did use AI, and that the State Bar would need to be notified if they did. To be clear, Kaplan did not use AI for the development of any of the questions that have been delivered to the State Bar thus far, and has committed that they would not use AI unless subject to significant discussion with the State Bar and pursuant to the direction of the State Bar. So I had mentioned the content validation panels, and so one of the things I just wanted to be clear, none of these questions, whether the questions that were developed by Kaplan, the questions that had originally been developed for the first-year law student exam and were taken from the bank of unused questions, nor the questions that were developed by ACS Ventures went from the developer straight to the exam. The State Bar had content validation panels, which were made up of representatives of newly licensed lawyers, supervisors of newly licensed lawyers, and some law school faculty to review the questions, looking for, and we talked about this a little bit at the last meeting, reviewing the questions, looking for, was it the appropriate level to test for a minimally competent applicant? Was there bias in the questions? Were the questions clear? These were all part of the review that these content validation panels engaged in. All of the questions, regardless of source, did go through that process. I wanted to move forward and talk a little bit now at a high level about the results from the February exam, which were released just this past Monday, May the 5th. We had initially scheduled from the beginning, from when the exam was first announced, that the results would be released on Friday, May the 2nd. But despite the Supreme Court's quick action on the petition that was filed on April 28th, giving us their order toward the end of the day on May 2nd, It was just simply insufficient time to for the court to have acted in time for us to present the process the results by Friday at 6 p.m. I do want to take a moment to thank the admissions staff and the IT staff who worked throughout the weekend to ensure that we would be able to release those results before noon on Monday, May 5th. We wanted to be able to release the results on May 2nd. We knew that was what we had promised that we would do, and we wanted to come as close to that as possible. And so staff did work through the weekend to make sure that we could process those results. So let's take a brief look at these results. You see here at a high level, the overall pass rate for the general bar exam, that's the 2-day bar exam, was 55.9%. The pass rate for the first-time takers, 62.1%, and for repeat takers, 53.2%. You have breakdowns. There's further breakdowns of data that's included as attachment A to the next item, which shows how these pass rates relate to the sort of historic 10-year averages for February exams. These are significantly higher pass rates than we have experienced over the past 10 years. For the attorney's exam, as you can see, for those who took the 1-day attorney's exam, there was 76.5% pass rate. And for those who were barred in other states but took the 2-day general bar exam, their pass rate was even higher at 88%. To go over some of the numbers that you heard in public comment, for the imputation of scores and the scoring adjustments for those who took the February exam, essay and performance tests, 45 test takers had scores imputed. 382, there were 382 imputations of multiple choice questions, and 527 test takers received the 40-point scaled score adjustment to their multiple choice as a result of having taken and met the minimum threshold for the November exam. Staff, myself, the executive director, I'm sure some board members have received numerous emails from test takers about the results and requesting a review of the results, requesting reconsideration and pointing to specific technological issues that they had. And we are also following what's on Reddit. And at least one public commenter has reported to you what's on Reddit, indicating that there may have been some anomalies, or that people are reporting some anomalies. I just wanted to let the board know that we are engaging in an in-depth review to determine if there were any anomalies, and we'll be able to make a public report of any findings of that review soon. I wanted to now turn to face forward. And
do you
yes.
want to add, I'm not sure you emphasized this, there was no AI used in grading.
Oh, yes, I apologize. Yes, that was a question. There was no AI that was used in grading. You heard from a public commenter who was concerned about that. AI was used just in the development of those 29 questions. The grading process was unchanged from prior years, led by the EDGE team, the exam development and grading team, and a pool of of approximately 100 graders. I'm sorry, I don't actually have the exact number of graders. The grading was conducted the same way the grading has been, human graders reviewing every question.
Can you go over briefly what is the standard appeals process for individual takers, and has that already taken place? Is there still an opportunity for that? How does that work normally?
Yes, thank you for asking, Trustee Huser. So the test takers have a very narrow opportunity to request review or reconsideration of their grade. It is based solely on there being a clerical error. The Committee of Bar Examiners has adopted a policy that indicates that they believe wholeheartedly in the vigorous in the rigorous grading process that we have under the leadership of this exam development and grading team. And so that the professional judgment of these graders is not going to be questioned as part of this appeal process. It really does revolve around clerical error. What we have seen in a lot of the emails that we are getting, people who are requesting reconsideration based on the unique circumstances that they face, the technological issues that they faced in the exam. And as I mentioned, those issues were taken account, or the Committee of Bar Examiners tried its best to take them into account by setting that raw minimum passing score at a level that they thought would provide, would reflect sort of the collective effect of all of those technological and other disruptions that people faced. And so people's unique circumstances with regard to the specific issues that they faced, as heart-wrenching as they are not grounds for asking for reconsideration or a regrade.
All right, Trustee Sewell.
Donna, could you just provide a little bit more clarification on the investigations that you indicated? Is that an investigation into some of what we heard in public comment surrounding whether or not answers to questions may have been attributed to individuals that were not responsible for those answers?
Yes, Trustee Sewell, that is what we are exploring.
Okay, so that, as well as, can you also sort of speak to what we heard, and I think many of us on the board have sat through probably close to 10 hours of public comment. Heard an awful lot today about accommodations that were not upheld. And has that been addressed in some fashion, or should we expect to try to deal with that from a remedy standpoint as well?
So I'm going to turn that over to Audrey Ching, Director of the Office of Admissions. She may have more information than I do about this particular issue, but in short, it has not been that issue has not been a part of a separate remedy. Those who receive the testing accommodations receive the same scoring adjustment remedies that all test takers did.
What I would say is that all the written public comments received and the emails into any of us that work in the Office of Admissions or through the applicant portal talking about ADA violations or accommodations not received, we are reviewing those all case by case.
And I would just add, in the item posted for the agenda item posted for the next item, we did include exam results for accommodated applicants. And so you do see, I believe, and Audrey, maybe you can take a quick look at that, a higher pass rate than for non-accommodated applicants, which is typical, but the amount of the higher pass rate as compared to non-accommodated applicants is greater than in prior years, meaning they passed at an even higher rate than accommodated applicants. So I think that's just an important, than non-accommodated applicants, an important data point.
All right, I see a couple of hands raised here. Go to Trustee Harrison next.
Yes, I had 2 questions. The first had to do with what the definition of clerical error is, and particularly with respect to the people whose accommodations weren't upheld. Does that constitute a clerical error such that their appeal could be recognized? And the second question had to do with the content validation panels. It was mentioned that there were law school faculty on those panels. I'm just curious as to whether those faculty were part-time adjunct faculty, full-time professors. Did they come from accredited law schools? I just don't know about who these faculty were and whether or not they could do the content validation process in an appropriate manner?
So there was a mix of representatives from different types of law schools, and there were the content validation panels occurred over a series of months, and so there were some who participated at the beginning, who ultimately were determined to have a conflict of interest and not meet the eligibility requirements, and therefore did not participate in the later content validation panels. But it was a mix of individuals. What we are doing going forward is we want to have a much more robust recruitment and selection process. And so we'll be presenting to the Committee of Bar Examiners at their June meeting a policy for their adoption about recruitment, selection, and eligibility criteria for content validation panelists and standard validation panelists, as well as a policy on the recruitment, selection, and eligibility for subject matter experts, who we are adding an additional layer of subject matter expert review into the content validation process. And we would be having the Committee of Bar Examiners participate in the selection of individuals as well. And so we do hope that a more robust recruitment and outreach process will have there will be we will have sort of consistent representation across the different law school types, and as well as strong representation from newly licensed lawyers and supervisors of newly licensed lawyers. So we certainly recognize the need for improvements in the process that we engaged in, and we'll be launching that with these new policies for the CBE's adoption in June.
Okay, and the clerical error question?
Audrey, perhaps you could address that?
Yeah, so the committee's policy reads that they will consider requests for reconsideration only when an applicant establishes with documented evidence that a clerical error resulted in failure or prevented the exam from being properly graded. So that's the language of the Committee of Bar Examiners policy. Again, the issues that applicants with accommodations are forwarding to us or who called in today, we are reviewing all of those case by case, sort of differently than the folks who are writing in with specific grading reconsideration requests about clerical errors, but we're reviewing both buckets of requests from applicants.
So we're unable to just say straightforward that applicants who had accommodations and were not permitted to use those accommodations for whatever reasons, that we can't just say that that was a clerical error.
Right now, we're reviewing all those reports into us, so I'm not able to say that's a clerical error at this time.
Okay.
All right, I think Trustee Grande is next.
Yeah.
To change
Yes, I had a follow-up question with Donna with the investigation. I know some of the comments today, they talked about the discrepancies, like a significant discrepancies between the first read and second reads. Is that going to be a part of the investigation you mentioned? Is that something that's being looked into?
So that's a great question. We are there is historically differences between first read and second read, and so it could be that on one question in the second read you got a higher score than you did in first read on a different question. Because let me back up. I apologize. When I want to make sure everyone understands sort of what qualifies for second read. So after all of your essays are read and given an initial score, your total scaled score is calculated between your multiple choice and your essays. And if that total scaled score is within 40 points, within 40 points of of the overall passing score of the 1390, then you are put into second read. If that overall scaled score at that point is 1390, you have passed. If it is less than 1340, I believe, then unfortunately you have not passed.
They're reading invalid essays.
If you're in that interim group, then you get that second read where they re-review your essays. And then some of those, as part of that review, and the reason that they do it is because although the essay review grading process undergoes significant calibration to ensure that there is consistency, overall consistency in how the graders are grading each of the essays, because there are about 15 graders per subject essay. They go through these processes to ensure calibration, but because there can be some differences, we want to give the applicants the benefit of the doubt and give them an opportunity for that second read. And so it could be that your first essay in second read gets more points than in first read, whereas your second essay got fewer points. The policy that's been adopted is that the scores, your first read scores and your second read scores are averaged. Certainly a different policy could be adopted where the higher score that you get, whether it be first read or second read, a combination of all of those could be what is adopted. That's not the current policy, but it's certainly something that can be looked at.
And well, I know there's a lot of hands up. I want to change what's showing on the screen because staff has been working on this analysis. This isn't pretty, but just so the board can see it while this conversation is underway. So somebody's working on making this into a better PowerPoint slide, but you can kind of see percentages that have gone to second read and the percentages who got a lower score after the second read, which is not intuitive, I think, to many of us. But this does show you that what we're seeing in 2025 is not anomalous. So again, we'll get this in a better format, but wanted the board to have the benefit of this data. Sorry.
No, that's helpful. Trustee Grande, did that answer your question?
Yes, thank you.
All right, thank you. Trustee Tony, and then Trustee Huser.
Thank you. Thank you, Chair Stallings, and thank you, Leah, for that slide because you answered one of my questions. I appreciate that. So I'm curious. I have a couple questions. One is about this content validation panel. And, you know, what I'm curious about, and you may not have an answer, and that's okay, but if these seem to be legal experts, okay, no matter who they are, they seem to be attorneys, and it just surprises me that they would review questions and not catch what so many exam takers have identified as problematic questions with more than one correct answer, questions that were poorly written. I understand we didn't have a copywriter review them, but I'm just thinking in my mind that someone who's a subject matter expert would catch that. Can you give some insight on that, please?
I don't think I'm able to. I just, yeah, I think it'd be speculation.
Maybe you can speak to, though, I mean, we have had all of these allegations, including the many comments by Professor Basic. We have had them assessed. We've sent them to Kaplan. We've sent them to our own subject matter experts. This is in addition to sending the questions to copy editing. And I would say just with respect to copy editing, for example, you've heard it was the questions were full of typos. Yes, there were some typos. I can't remember the number. I think it was less than 5. Yeah, so, and the same, there is not a widespread agreement about the level of all of these errors. So I think that that's part of our challenge. I mean, you're certainly hearing these assertions being made. I don't think we would dispute that there are some errors. The extent of them, I think, is in dispute by the folks who are reviewing them. And I don't know, Don, if you can say more than that about what our subject matter experts have said, or even Kaplan, but I do want to assure the board we've looked into all of it. And one of the challenges is everybody doesn't agree on about some of these assertions that are being made. Yeah,
Okay,
Yeah, I don't think I have anything else to add to that.
let me go to my second question, and it really has to do with the Kaplan contract. I guess as a trustee, I kind of assumed that we're giving millions and millions of dollars to Kaplan to come up with a new set of questions. I guess maybe I fell asleep or missed something, but I thought if there are 200 questions, that they were going to come up with 200 questions. I'm really surprised to find out they only came up with 117. And I'm surprised that, I don't know, I mean, I don't understand why you would use first year questions on a test that's supposed to, I would presume, test competency after 3 years. You know, and I know that the board was never told about AI. That was never brought up. And so I guess my main question has to do not so much about the AI in the first year, but how come Kaplan, I mean, how is it? Did our contract say they only needed to develop 117 questions out of the 200?
So my understanding is that Kaplan that Kaplan met the terms of the contract. Kaplan developed the number of questions that were required in the contract. As part of the content validation process, you do go through questions and decide that this question is testing too niche an area of the law. This question is at a level that's too high for a minimally competent attorney. And so some questions get thrown out, some questions have to go back into the pool to get revised. And so although they may have produced X number of questions on one date, several of them maybe are being revised and are not ready in time for the next exam. But they did meet the requirements of the contract. It is not that suddenly we found ourselves with only 117 questions in hand and we had to and we had expected more. We didn't. They met the terms of the contract, and part of it is the date at which the contract was entered into. The contract was entered into in early August, I believe, is somewhere between the 7th and the 9th of August, and that's not a lot of time to develop questions, and so that was why we included in the contract that they would have as source material the questions from the first year law students exam, because those would cover 3 areas: criminal law, contracts, and torts. So those areas would be covered with those questions, and they could focus on developing questions in some of the other areas that we didn't have questions. Again, I would say that the first year questions, despite the audience they may have been developed for initially, all went through this content validation process where it was determined whether or not these were too easy, too hard, should be made more difficult, should be made more easy. And so the expectation is that that content validation process would negate sort of any effect of the fact that these were developed for the first year law student exam and make sure that they are appropriate for the bar exam.
I appreciate hearing that the 200 questions that were prepared by Kaplan underwent vigorous scrutiny so that 83 of them were deemed not appropriate or not, didn't meet the standards. I think that in future contracts, I assume that when someone is contracted to do work, that they have to meet the standards. And I'm just a little bit surprised that they can just give 200 answers, questions, and they're done with it. If 83 of those 200 don't meet the standards that the state bar wants, then I believe that a contractor is obligated. And if it's not in a contract that way, we should learn from this lesson and make sure that that it's clear in the future. That's all I have for now. Thank you very much.
Thank you, Trustee Tony. I'm going to go to Trustee Huser, but I want to be mindful of the time. We're starting to bleed over into our next agenda item, which are the remediation measures. So I do want to make sure that we can get to the resolution on item 3.1. So Trustee Huser, does your question relate to 3.1 or more on 3.2?
Well, it's a combination of both, but it's related to the discussion we just had. So I just want to make sure my understanding is correct. The accommodations, the people entitled to accommodations are getting individual review. That's been confirmed. The people who got second reading got an average, and I think we should consider in the next section whether we go with the high score on that. And the third thing is for the appeals process, I think we should consider whether preventing proper grading, as is the standard in that, would include this whole section so that if anybody individually wants to appeal, that they have the opportunity to do that. So hopefully we can talk about that in the next section.
All right, we'll go to the San Francisco building. I can't tell who has their hand raised. All right, Trustee Good, again, kind of similar question. Is this a 3.1 or a 3.2 discussion?
I think it's 3.1,
Okay.
but I'll keep it really short because I know we have a lot to cover. I just wanted to add to Trustee Tony's comments on the multiple choice creation by Kaplan. I was somewhat disturbed to hear that part of the rationale for supplementing the 100+ questions that Kaplan developed was that they didn't have a lot of time to develop the multi-choice questions. Because I recall multiple board meetings where we were told, notwithstanding our skepticism that it was on a short schedule, that everything was going to be done appropriately and that everybody had enough time. So I'm disturbed to hear that. And presumably on prior bar exams, 100% of the questions would have been created by the national conference, right? So this would have been a departure that I would have appreciated, hearing about. And I'm just a little stunned to hear that part of it was because there was not a lot of time. So that's it. Thanks.
And if I could just clarify, and I apologize, I don't have the specifics off the top of my head on this. The contract was executed long before I took this role. I don't recall the specific number of questions that Kaplan was asked to develop for February. I think it was less than 200. I do want to clarify that. And again, the expectation was that subjects like criminal law, torts, and contracts, that the first year law students exam questions would be part of what was being used for those. So I just wanted to the best of my ability off the top of my head, just wanted to clarify that one point.
Right. Donna, can you move on to the next item in your presentation?
Yes. Going back here, so I'm going to go very quickly over these slides. Just letting the board know that we identified the test sites. Took many of these to the contracts committee on took these to the contracts committee on April the 2nd. We are still executing some of these contracts, but we've lined up the sites that are identified on this slide for the in-person administration. The cost of these sites, just these sites, is about $1.7 million. And just pointing out that we did decide to open up the Los Angeles State Bar office to approximately 160 test takers with testing accommodations, so we could provide reduced distraction rooms, semi-private rooms, and private rooms. We have projected as many as 10,000 applicants. As of this morning, we now have about 8,400 applicants signed up. We've projected the need for 1,400 plus proctors, and there are over 1,000 proctors who are already connecting with staff expressing interest. Not officially lined up yet, but over 1,000 who are expressing interest. So that's good news. Just updating the board on what was approved by the contracts committee here on the slide. And then just identifying some additional costs that we have. The cost of transitioning to the MBE is $72 per applicant, with an estimate of 10,000 applicants. We're looking at $720,000 for that. That was directed by the Supreme Court. We'll be bringing that contract to the board at the May meeting. That should lead to a reduction in the contract with ExamSoft, because the $110 per applicant price was when we were planning on loading the multiple choice questions in the ExamSoft platform, which we cannot do with the MBE, so that'll reduce that cost just a little bit. And then just a reminder, we were just talking about Kaplan. We do have a multi-year contract with Kaplan, and we will continue to incur costs despite the return to the the MBE for the July exam. Moving forward to the final point that I wanted to bring to the board for action here. In February, the board adopted this resolution that's on the screen, approving $3.1 million in the budget to support fee waivers for the July 25 bar exam. For those who did not succeed on the February 2025 exam, or those who withdrew from the February 2025 exam. The Committee of Bar Examiners on May the 5th took up this action by the board to recommend expansion of it so that the fee waiver could be used by those same applicants, not just on the July 2025 exam, but perhaps on February 26 or July 2026, whichever one they choose to sit for first. It wouldn't apply for all three, just whichever one they sit for, they would be able to use that. Some are not able to take the July 26 exam, as you've heard, the July 25 exam, as you've heard from some public commenters, and this seems fair and appropriate action to take. It will also could result in some fewer test takers in July 25, those who might be taking the exam because they have the waiver, who would prefer to take it at another time. And so as part of that, the Committee of Bar Examiners also adopted a recommendation that that those who applied for the July 2025 bar exam, because of the fee waiver, be allowed to withdraw from that exam and use that fee waiver in one of the 2026 administrations. And then finally, just to note something that another action that the CBE took that does not require board action, but would go directly to the Supreme Court, is the committee asked the Supreme Court, along the same lines with this fee waiver, if we've extended the fee waiver past the July 25 exam, to also allow the scoring adjustment for the November exam to extend to those other administrations as well. So again, whichever one you sit for first is when the scoring adjustment for the November exam would be applied. That recommendation will go to the Supreme Court. As a result of the CBE's action and the board's prior action, we've developed the following recommendation for the board's consideration and vote.
All right, any questions about the proposed resolution? Trustee Barahona.
Thank you, Chair Stallings. I just think from a financial modeling perspective, it would be helpful to understand how this impacts the budget. I don't disagree with moving this item forward. But I do think that this does move us in a different position financially, which we've been working towards getting right over the last several years, and I think have made some great progress. And we want to make sure we make the right remediations, and I understand this to be a part of that process, but I do think that we will need to understand the impacts to future fiscal year budgets as a result. So I just want to make a note of that, Donna, or you.
Yeah. And I don't, this action shouldn't, it's in and of itself is not what should be impacting the budget. You'll see here that, that I mentioned a $4.9 million number in this resolution, which is different than the 3.1 million that was approved by the board. The reason for that difference, is not because it's extending it over over 2 years, over 3 administrations, but rather that the 3.1 million that was previously approved by the board, despite the board's resolution, was built on an assumption of a 35% pass rate, but did not build in the cost for the fee waiver for all of those who previously withdrew for the exam. And that had been part of the action, but the math hadn't been done. And so this 4.9 million is taking into account the 56% pass rate. So fewer that would be that were unsuccessful that would need to take the exam again, but incorporating the 1,400 individuals who did withdraw from the exam.
So then, I mean, just from a budgetary standpoint, would it be, I guess, when do we need to make this decision as it relates to people signing up, making those decisions? Is it something that we can push till our next board meeting in a couple of weeks? Maybe have the finance department or the finance committee look at this a little bit more closely, or do we not need that level at this point?
I think we need to make a decision because it's impacting applicants' decisions about registration and studying.
Appreciate that, Trustee Tony.
Thank you. When I look at the recommendations from the Committee of Bar Examiners, they certainly make sense to me. I'm looking at the third recommendation that doesn't require board action, and that also makes sense to me. And what I'd like to do when it's appropriate is to move the proposed resolution with the amendment of the additional Committee of Bar Examiner recommendation. I understand it may not require the Board of Trustee approval, but I think that it would, I certainly don't think the Supreme Court would object to the Board of Trustees. I mean, it's their decision, obviously. We're just making recommendations, but I don't see where, there'd be any objection to the Board of Trustees adding our support.
Right, so is that a motion that I hear?
If it's appropriate, yes. My motion is to the proposed board resolution as written with the addition of the third recommendation of the committee.
I'll second.
All right, so first by Trustee Tony, second by Trustee Sowell. Do we need any clarifying language in the resolution to accomplish Trustee Tony's desires?
Donna, would it be possible to go to the next slide?
You mean the prior slide?
I mean prior, yeah. Perhaps then the additional resolution could just say that the board supports CBE's recommendations pertaining to the extension of the November study to the 2025 and 2026 administration. So I just would add that the board supports. If that aligns with Trustee Tony's intent in making
it is. Thank you.
Okay.
Thank you very much. And to me, they all fit together, actually. It's part of a package.
Louisa, do you need time to wordsmith that, or are we okay voting on the resolution as it's put up on the screen?
Donna, do you want me to put that into a document for you?
Yeah, I can't, well, in this, I can do it here, I guess.
Yeah, I have it if you want to.
I've got it.
right, Trustee Tony, does that language reflect your motion?
Thank you very much. Yes.
All right. Unless there's any further questions or comments, Madam Secretary, when you have a moment, can we take a roll call vote?
Barahona,
Aye.
Buenaventura, not present. Cisneros. Cisneros,
Aye.
thank you. Good,
Aye.
Grande,
Aye.
Gore,
Aye.
Harrison,
Aye.
User,
Aye.
Soel,
Aye.
Stevens, not present. Tony,
Aye.
Trejo, not present. Stallings.
Aye.
It's 10 ayes, 0 nays, motion carries.
Great, thank you so much. All right, we'll move on to item 3.2, and I believe Donna is also presenting on this.
I'm actually going to share my screen. Dawn and I are presenting together. Okay, I think everyone knows what we're discussing. It's just a recap on April 2nd, you asked the Committee of Bar Examiners to come back with a full range of remediation options with some specific parameters. Monday of this week, on May 5th, they have considered a range of remediation options and brought forward expanding and extending a provisional licensure program, and then also admission on motion, and in the interim, special admission for attorneys. And that's what part of what we'll be discussing. So here in the next couple slides, I'm going to look at some of the demographic data and applicant type data going back 10 years, and then with the release of results this week, including the pass rates for the February 2025 exam. So all of these columns are February exams, so it's year over year with February. Nothing from the July administrations are in these comparisons. And you can see broken out by the demographic data that we ask for, that we do collect, is on the far left. And then you can see on the very far right what the pass rate was in this February exam. It's probably helpful to look at this column in terms of the average over 2015 to 2024, and looking at all the pass rates far above the average for those other administrations. This next slide, I was trying to, you can tell me if it's really hard to see where you are, and I could probably share it a different way. Trying to fit this on one slide as well, just so you can see the comparison. So when I say all test takers in that very first row, that's including everyone who sits for the 2-day exam, and then the small number of attorney takers. So if you're an attorney who's been licensed in a U.S. jurisdiction for 4 or more years, you can elect to take just the written portion and not take the multiple choice. So all test takers here includes those who take the 2-day and those who take the 1-day. So this is the pass rate for everyone in 2025. And then the second row here are those testing with testing accommodations. Also, it's apples to apples, also the 2-day and the 1-day exam. You can see the pass rate that we talked about a little earlier, 65.1%. This year for those testing with accommodations. The average for that group is for February administration, it's around 31%. And then you can look back at the year by year, close to the all test taker pass rate year over year for the past few years. And then you can look back. 2019, we transferred systems. So there were hard copy applications and some in a different database. So that is why this data point is actually not available for you today. We have never reported this in our exam statistics. So this was collecting and getting this data just in a variety of different ways for this meeting. Again, the attorneys 1-day exam. So again, those are the ones who elect only to take the written portion. There's disciplined attorneys. The general bar exam. So everyone taking that 2-day, the first time taker rate, repeat taker rate, and then attorneys who either choose to take the multiple choice or have been licensed under 4 years. That's their pass rate. And then broken down by the legal education type, our ABA in California, ABA out of California, Cal accredited, Cal unaccredited, law of the study not reported, because if you're under 11 takers, we don't report that data. Foreign attorneys, and then foreign educated. Okay. These are the different remedies. I've added in some that we heard in public comment earlier this week at the Committee of Bar Examiners meeting. I think there's others that we've heard today. Provisional licensure with the bar exam requirements. So this time-limited temporary license practicing under supervision that will require passing a bar exam to become fully licensed. Provisional licensure with a pathway to licensure, so supervised practice, but would lead to full licensure. Portfolio bar exam, alternative demonstration of competence through submitted legal work and supervised practice, which does not require passing a bar exam. Special admission for out-of-state attorneys. So we have many special admissions programs under multi-jurisdictional practice. So looking at the registered military spouse special admission, looking at that kind of rules of court, modeling it after that, and then those attorneys could practice under supervision. Admission on motion, so full admission without a bar exam for experienced attorneys. That does require a statutory change. Diploma privilege, admitting based on law school graduation. Past those who qualified for second read, I think that came up a lot in public comment. So passing those who went to second read in this administration, that means their first read scores were within 40 points of the cut score. I did hear another suggestion where perhaps those who went to second read could have provisional licensure with a pathway, and those who did not could be have provisional licensure without a pathway to licensure, to full licensure. Also, Trustee Huser mentioning maybe taking the higher of the two scores in second read and not the average. Prior performance imputation, looking, and this would only apply to repeat takers, looking back at prior scores, perhaps combining a prior performance test score and imputing into this exam to make for a passing score, and then substituting component scores. So substituting a prior administration's written section or multiple choice section in place of one of the component parts of this exam to equal a passing score. A partial retake, retaking only one portion of the exam, for example, the PT, and then maybe passing everyone who was within another 80 to 100 points of the cut score for passing February 2025. These are all the populations that we looked at. We have been considering first-time takers, repeat takers, those who withdrew from the exam, U.S. licensed attorneys, either those who could take the one-day or who could not, or who elected to take the two-day, foreign licensed attorneys, foreign educated law graduates, ABA graduates, Cal accredited graduates, registered unaccredited graduates, law office study, looking at populations by race, ethnicity, gender, age, testing accommodations, second read, and then disbarred California attorneys. Their reinstatement actually requires an exam, but that is also another population. There a hand raised? I'm sorry, I'm sharing my screen.
Yes.
Yeah. Is that Trustee Harrison?
Yes, it's Trustee Harrison. So, okay, I guess I
You want
can
me to
ask
go
my
back?
No, I'm just a little confused regarding the options presented that include not having to take a bar exam, and I'm confused because under the Business and Professions Code 6060 subsection G, it requires someone admitted to practice law to have passed the general bar examination given by the examining committee. And so, I mean, are these recommendations, are these suggestions for us to recommend to the Supreme Court to do something that's contrary to statutory law?
Well, two of these, the top two are actually current programs. So provisional licensure without a pathway is the Rules of Court 9.49 based on the 2020 graduates who were impacted by the pandemic. And then provisional license, that same time frame, there was a provisional licensure program where if you were within 40 points of the cut score, you could have a pathway without retaking the exam. That's 9.491. And then yes, if you were admitted on motion without taking the exam, that would require statutory change.
As with the portfolio bar exam, which
yes.
one of the rationales when the court denied the recommendation from the Blue Ribbon Commission, because the statute specifically requires passing of the general bar exam. And so that would be something that would require a statutory change. We'll sort of move forward. These were all the options that were recommended to the Committee of Bar Examiners. We'll certainly get to what the committee recommended, but we wanted to make sure to present all of those options to you because the committee focused in on 2 of those particular recommendations.
Donna, do you want
Okay,
to?
but one thing, the Blue Ribbon Commission did not recommend the portfolio bar examination. It was a minority working group of the Blue Ribbon Commission that recommended it, and the Supreme Court drafted and published a well-reasoned order why that was not a good idea they wanted to implement.
Yes, I misspoke when I said from the Blue Ribbon. The order came down together with the order about the Blue Ribbon Commission recommendations, as well as the recommendations from the minority working group.
Donna, just to make sure the board is all aware, my understanding is there is a current pending legislation that is emergency legislation that, if enacted, would remove that requirement for the general bar exam. Is that correct?
Would remove that requirement for attorneys who have been licensed for more than 4 years. Would allow those attorneys. Basically, what that is doing is allowing the court to adopt an admission on motion or reciprocity, because that was one of the barriers that the court cited in their order for why they did not adopt the Blue Ribbon Commission's recommendation for reciprocity. So that is urgency legislation that is has passed out of its House of Origin. So it's Assembly Bill 1522. It is now sitting in the Senate waiting to be heard, and it would allow attorneys with more than 4 years to be admitted without taking a bar exam, and would allow attorneys with less than 4 years to be admitted following passage of an exam prescribed by the committee. So that could be the general bar exam. It could be something else.
Trustee Sewell.
I have a clarifying question on, if you just go back to this slide, just in terms of our authority. I understand that the item itself only makes recommendation of a couple of these non-scoring remedies, but if we as a board were to take action to add additional scoring remedies or to modify these in some fashion, do they have to go back to the Committee of Bar Examiners, or do we have the authority to make those, to exercise those remedies ourselves?
Chair, Don, I can't see the entire panel, so I could take that, but that's a great question, Trustee Sowell. On the specific remedies that pertain to scoring adjustments, my recommendation would be that it go back to the CBE to be consistent with the court rules that provide authority to the CBE to make those recommendations.
But not necessarily to the court, right? So for example, the board wanted to consider something like modification of the second read process so that you get the highest score between the first and second read for each item, something like that. That would go back to the CBE, but would not need to then go to the Supreme Court. Is that right? Because it's grading essentially and scoring, not setting the overall pass line.
Let me confirm that, and I can answer in a minute or so.
And could you also confirm the issue of, I assume, any scoring adjustment that is made for anyone who has accommodations and those are being reviewed individually, that those score adjustments could be made? And also, just process-wise, if for the appeals process, if there's, I think it's your last one here, if there's a certain, or it's, if there was a certain score under which we did a kind of appeals process. You know, where does that have to go for approval?
I think if it was the appeals process, the way Trustee Huser, you just sort of referenced it, for people who got a score below a certain level, they would be entitled to a regrade, right? To look at their grade. Wouldn't change the pass line. It would be another look at the grade. I believe, I would expect that would go back to the Committee of Bar Examiners, but not the court.
I would think so too, based on the fact that it was the Committee of Bar Examiners that removed third read several years ago, 5 years ago. So.
Trustee Harrison.
So if the board here today decided to recommend that with regard to the second versus first read situation, the arguments we heard during public comment, if the board recommended that for this February 2025 bar exam, that whatever the highest of the two should be the one that we go with. Does that go to the Committee of Bar Examiners, or does that just become the order of the day and we just move forward with that mandate, or would that be a recommendation that we would make to the Supreme Court?
I believe that would go back to the Committee of Bar Examiners.
But I think our general counsel wanted a little bit of time, Trustee Harrison, to give a definitive answer.
Okay.
Not particular.
So let me just take this opportunity. We're agendized to go to 1 o'clock today. Do any trustees have a hard stop at 1? How about account see any hands? Anybody have a hard stop at 2?
I do.
Okay. Trustee Harrison. All right. Want to be mindful of everybody's schedules. I know this is an important issue, and we do have closed sessions still to get to. Donna, would it be helpful to finish the rest of your presentation, or Audrey and Donna, would it be helpful to finish the rest of your presentation and take a few more questions, give Aline a little bit more time?
Sure, I will just review what the recommendations were from the CBE. So to expand that Rule 9.49 to include February 2025 exam takers who were unsuccessful or withdrew, and then sunset it 2 years after those new rules were adopted, or December 31st, 2027. So 2 years, whichever is later. Authorize us to set reasonable application costs, and then also extend it for the 71 current provisionally licensed individuals who are still in the existing program, who otherwise would have to exit by the end of this year. Just to have, there was a table that I included in the item, but this is a slightly different look, which is what is the complaint, investigation, and charge rates for provisionally licensed lawyers to date. So again, that program started in 2020. So looking back over the years, in the item, the chart that I had in there was about the entire attorney population, the entire population and their investigation, complaint, and charge rates. And this is breaking it down a little more to something perhaps more similar, which is very newly licensed active attorneys. So even looking through this lens, it's very similar rates. They're investigated, provisionally licensed lawyers are perhaps investigated at a slightly higher rate, but not led to any more charging. So that was just something to consider for you to have today with all your discussions. The second recommendation from the Committee of Bar Examiners, I think Donna just explained really well, that Assembly Bill 1522, again, allowing the attorneys licensed in good standing in other U.S. jurisdictions to be admitted without taking the bar exam. This was part of the committee's recommendation on Monday. Then we'd have to develop a new admission process if there is that statutory change. In the interim, developing a new rule of court modeled after the registered military spouse attorney program that exists. That program allows supervised practice in California for qualifying attorneys while broader changing is pending. That's what that interim program would be like. And then I think we can now, I'll just stop sharing and get to everyone's.
Can I just ask one very quick question on that last slide? That didn't seem to say only for February bar takers. It seemed to be a broader.
Sorry, the overall heading of the resolutions from them was about February 2025, who withdrew or were unsuccessful.
All right. So going to questions, first, Trustee Harrison.
Yes, so for the provisionally licensed program, it's my understanding that program was created because of the emergencies occasioned by the COVID-19 pandemic. It was continued a couple of times for various reasons, but now we're talking about continuing it for the exam test takers for the February 2025 exam because of the bar exam debacle. Help me understand the reasoning for allowing the folks who entered that program in 2021 to still be allowed to remain in that program now that we have a new reason and a new rationale for considering it. And coupled with the fact that under the Business and Professions Code, these folks who want to become licensed attorneys need to take a bar exam at some time.
Sorry, I missed part of that, but the committee's rationale for including the 2020 graduates who haven't completed passed the bar exam to exit the program. Is that right, Trustee Harrison?
Well, I would hope that those folks who started the program back in 2021 wouldn't be continued because of this more recent bar exam situation, that the provisionally licensed program should only extend to the folks who are injured by this current bar exam situation, not benefit the folks who entered the program because of COVID-19. That's my main point.
I think we could, the resolution from the board could be amended that way. The committee of bar examiners looked at that program sunsetting at the end of the year and thinking the ones that were still in the program could also be extended throughout the new extension for this February 2025 cohort.
The rationale being not predicated so much on the original impetus for why that program was established, but rather the fact that we now have nearly 5 years, 4 years of a track record for these individuals. As you can see from the data, there's nothing to suggest that there's a public safety concern or a public protection concern. And it is an access issue both for the current provisionally licensed and for the clients that they serve. So we've heard repeated testimony from those folks, their supervisors, about the benefits of the program. So I think the idea is if we are going to bring in a new cohort, extend the date for that cohort, obviously, that, one approach that would have some benefit is to just roll in I think 70 remaining existing PLLs into that expanded and extended cohort.
All right, going to the San Francisco meeting room.
Thank you, Chair Stallings. What I'm struggling with is looking at the data, and thank you very much to the admissions office for pulling together the demographic data that I think I asked for, as well as some other things here, which is really useful. What I'm really struggling with is if we look back at the demographic data, right, the overall pass rates are tremendously high based upon what it ordinarily would be for the February bar exam. Jumping from 33% to 58% for men, 54% for women, jumping from 29% for Asians to 51%, 21% for Black potential attorneys to 52%, Hispanics from 28 to 52%, white applicants from 40% to 63%. And then just looking at the data, across people who took the attorney's exam as well as the 2-day exam, and then cutting across ABA approved, California accredited, mean, California accredited schools, as we know from prior programs, have a really not very high pass rate of California bar. And here it's jumped from a 10-year average of 17% to 46%. And then the Cal registered unaccredited jumped from 15% to 45%, with the ABA rates, you know, going up from 40% to 68%. So what the data is showing is, you know, across the board, people are getting, you know, an order of magnitude of 20% plus higher pass rates, the highest pass rates undoubtedly in California's history. We're not seeing any racial disparities. We're not seeing any disparities based upon where you went to law school. If anything, the racial disparity gap is narrowing for this bar exam, which is curious. I don't know why. I'm having a hard time understanding why the Committee of Bar Examiners is recommending that everyone who failed the exam, as well as people who just withdrew and didn't take the exam, should be provisionally licensed. I'm just not getting it. So someone needs to explain why that's an appropriate remedy here in light of these tremendously high pass rates.
Anybody on staff want to summarize CBE's discussion?
They had the, for the most part, they had the same charts in terms of the pass rates on Monday that we're looking at now. And I think hearing public comment and understanding the circumstances of the exam, they thought the best and the fairest thing for the pool was to allow them to have access to practice for 2 years and then still have to retake a bar exam.
Yeah, I mean, I
those that
agree.
withdrew.
I agree. I think they were largely moved by the public comment and the circumstances as they've come to understand that occurred at the exam, and that is what motivated the recommendation. Though certainly, Trustee Good, there were those who raised that very issue.
Yeah, it wasn't a unanimous passing of those recommendations, so there were dissenting opinions.
Well, for my part, I have a hard time supporting that proposal because I feel in a way that it would betray our obligation to ensure competency of all attorneys in California, to just let everyone in who applied to take the exam, even if they withdrew, and everybody who failed. You know, what's the purpose of a bar exam if you let everybody be provisionally licensed who failed? And certainly, I completely appreciate the disaster that was the February 2025 bar exam. I completely find a lot of the individual stories from applicants really kind of heartbreaking. But I don't see how we can just open the doors to provisional licensure for everybody and fulfill our duty to the public of ensuring a basic level of competency there. I appreciate that the disciplinary data shows that folks who were provisionally licensed during the pandemic are disciplined in the same amount as other kinds of attorneys, but competency isn't tested by whether or not a complaint is issued against you. We all know that clients sometimes are unable to appreciate if their attorney was competent at all and thus even make a complaint. Or they, you know, there's underreporting for it. So I don't think the absence of discipline means competency. And so I'm very concerned about this provisional licensure proposal. You know, I would have to really be persuaded that it was a good idea to go for it. But right now, I don't see it as consistent with my fiduciary duty as a trustee to approve this. So that's kind of where I'm coming from, just in light of all of these tremendously high pass rates.
All right, thank you, Trustee Good. Anybody else there in San Francisco? All right, going on. I think Trustee Huser's next, and then Trustee Tony.
Yeah, I 100% agree with everything Trustee Good just said. I have a lot of problems with, you know, these two proposals, both of them, because of the historically, you know, extraordinarily high pass rate. I appreciate all of the work that the Committee of Bar Examiners did to come up with several creative solutions to allow these historical pass rates and to give every, opportunity. But I cannot condone giving provisional licensure to people who failed, or God forbid, people who just didn't take the exam, or for out-of-state attorneys who passed at a rate of, I think it was 88% who took this 2-day and 76% who took the 1-day. But so saying for anyone who's out of state, just because you were licensed out of state, suddenly you just get a bye here. So couldn't agree with that more. However, I did find it very compelling in the public comments, and I'm very happy to hear that anyone who had an accommodation has the right to get their review. And I think that's appropriate, and I've heard that is happening. I think we should also consider those who had a second reader and went down because of it, whether we look at the average, which they were brought down on, or whether we should look at the higher of the two. And third, whether there is a narrow band, maybe it's 40 points, something like that, where there is a group, with somebody in public comment mentioned they had less than a one point score difference, whether there is some sort of very narrow appeal process for those people. So that would be a score adjustment based on individual circumstances and individual scoring. Would be the thing I would consider.
All right, Trustee Tony.
Thank you, Chair Stallings. A couple of thoughts here. One is, I think it's okay for there to be a high bar to practice law in California. I think that's okay. I think that's a good thing. I think it's a good thing that historically the pass rates for the state bar has been really rigorous. And so one thing is, I wonder, and maybe we'll find out at some point, with this, new testing regime that we switched to, if the standards themselves were lowered too much. Okay, so let me just start by saying that. Okay, I think there should be a high bar to practice law in California. I support that principle. Okay. I also, at the same time, support a principle of plain fairness. And despite the high pass rate, I think we're in a situation we've never been in before, which is that every person who did not pass, every person, first we have to acknowledge everyone, virtually everybody had a nightmare, whether they came to a testing site or whether they took it remotely, right? Just for this meeting, there were 170 pages of written public comment submitted. And I know myself and other trustees have received dozens of other direct written comment in between, during the past few weeks. And so what we have that's really different is everyone who didn't pass has a feeling that they would have passed. They could have passed were it not for all the technical difficulties. And I can't say I certainly understand that feeling. I understand that feeling. So that's one. I think another thing is that the last time this question came up, I was not crazy about the idea of provisional licensure. okay? And I will say that spending more time with the public comments, reading them, listening to them, taking a look at what the Committee of Bar Examiners is recommending, I'll just let you know, this is something I can support. And the reason is because I think we are in a situation where it is fair for us to support. Remember, Supreme Court makes the decision, we're making a recommendation, but to support a recommendation of universal remedy. And that's what this looks like to me. It's not everything that everyone wants. We've heard from the testimony, we've seen in the written comments that there are many more recommendations that people have made that they would like to see. So I think this meets examinees halfway. It is not anywhere near what people feel like they deserve, and yet it is a universal remedy which comes to us from the Committee of Bar Examiners, so it will have my support.
All right, Trustee Tony and Ms. Hershowitz, did you have a response?
It's actually not to Trustee Tony, to something that Trustee Huser had mentioned. Trustee Huser, one of the things that you were talking about was an appeal process, which I take as sort of another read for a third read for a narrow band of individuals. I just wanted to point out that the grading process up until 5 years ago had a third read. It was the 2 reads that we currently have, plus, and Audrey, correct me here, I think it was if there was a 15-point differential between, was it on any single essay, Audrey?
I think it was on the total. I think it was on the total, but yes.
So if there was a 15-point differential, we think on sort of the total between what the first read came up with and the second read came up with, then there was a third read. The committee received data and a presentation from a prior psychometrician that the committee used to contract with. And the data was that the third phase of reading added an extra week to the processing of scores and being able to get scores out. And 2, it though for any individual that went from a fail to a pass, you understand why it's important. But overall, statistically, it was incredibly unlikely that you would go from a fail to a pass with that third read. And so the committee decided to eliminate that phase of the process. So I just wanted to bring that up in case, just because what you were suggesting sounded kind of like going back to that.
Yeah, thank you. It's very helpful.
Right, Ms. Daptian.
Yes, thank you so much for giving me the opportunity to confirm. But to answer the earlier question about changes to, swapping out the higher second read scores or vice versa, the court was presented in the petition with what we understood to be all of the scoring remedies, and they adopted the CBE recommended lower raw score in reliance to that information. The court may feel that they would need to sign off on those types of adjustments because these going to be applied retroactively. I don't have an specific answer whether or not they would, but what we could commit to is at least reach out and inform the court, and if appropriate, then we would submit a petition to the court. I'm not, to my knowledge, this has not happened in the past, so it may be a novel issue.
All right, I think it was Trustee Harrison, and we'll go to San Francisco.
Thank you, Chair Stallings. I know I couched my prior comments in questions, but I just wanted to make my position clear. I, for the most part, agree with Trustee Good's statements about the provisional licensing issue in the context that there was such a higher pass rate for this bar exam, notwithstanding the technical difficulties. But I'm really concerned about what seems to be somewhat of a normalization of provisional licensing. I know that we had a crisis in COVID-19. Now this is a new crisis, but the law requires new attorneys to take and pass the California bar exam. And even if we did go with the provisional licensing for these more recent test takers, I am firmly against extending that for the ones that have been in this program for the past 4 years. I think that they need to comply with the law and take and pass the California bar exam.
All right, going to San Francisco.
Thank you. Weighing in also on the provisional licensure program. So my thinking here is there may be a bias towards economic capabilities. If we remove the provisional, and we've heard from the test takers, or some of them had significant economic impact of, missing wages and having to stay and all those pieces. And so if you don't have a provisional program, then those who can afford to do it again, to take the test again, can, and those who cannot, then are we excluding a group of people just on an economic basis? So I would just want to add that to the conversation, and my perspective that it would be an unintentional economic impact.
All right, Trustee Grande.
In reflecting on some of the public comments, and one of the comments stood out to me where, the individual was 12 hours for her bar exam, right? And I think that I don't know if provisional licensure is the pathway, but I do think looking at the best of both scores, I understand that it may have already been one of the options presented, but I don't think that it wouldn't be within our purview to bring that up again. Some of the other things that I see is, what was the other thing? I just, oh yes, the imputation of scores. I mean, where I just see that people that didn't, and I wasn't at the CBE meeting, so I didn't hear the conversations about this, but as a former law student and someone who took the bar in the past, the answer was always like, you gotta fill something into the responses, because you just gotta get that in. And I just don't think that we're adequately dealing with people that followed the coaching that they got for the bar exam. We're not addressing that sufficiently, so that maybe they just take that particular aspect of the exam that they didn't pass. But I do think even though we do have higher percentages, which is great, it's great. I think that the lack of disparity that we're starting to see is we're moving in the right direction. But there is something to be said for what people went through, in particular the ones that were there for way longer than they had to be. There was an impact. I think there is something else that we can do. And I think some of the scoring, looking at some of the different things that Trustee Huser said earlier, would address some of that.
Right, Trustee Sowell.
I think I just, first of all, just want to thank my fellow Board of Trustee members for just the fullness of this discussion, because it really has helped to provide some perspective on my part, as well as help to fill in some gaps. But I do still have a couple of clarifying sort of questions based on I know we don't have a motion before us, but what has been recommended by the Committee of Bar Examiners, just to clarify for me. On the out-of-state attorneys issue, which appears to be one of the recommendations of the Committee of Bar Examiners, that sounds like that is subject to statutory change, and so that's out of our control as it is, because if I was understanding correctly, there is a bill, AB 1522, that's currently working its way through the legislature that addresses that issue. Is that correct?
That's mostly correct. The CBE did put forward to recommend an interim program of especially admitting out-of-state attorneys through like the special admissions multi-jurisdictional practice. So setting up another program like registered military spouse attorneys, where someone from out of state could practice as an out-of-state attorney under supervision. And that could be an interim program set up until that statutory change is made.
But I would also note that the statutory change does not mandate that that's what happens, right? That we absolutely let attorneys do that, have admission on motion. And so this was the CBE wanting to say, if that statutory change happens, Supreme Court, we are telling you that we believe that we should adopt admission on motion, and letting the board and then ultimately the Supreme Court basically just sort of say yes or no. If that legislation is adopted, we agree that we should do this, or we don't agree that we should do this. But it was basically getting ahead to say we may have this option when the statute is passed.
Okay. Thank you for that. And then my second question is on provisional licensure. And what is before us, or will be before us in terms of the Committee of Bar Examiners' recommendations. I do understand that it captures the entire universe of folks that either withdrew or were unsuccessful on the February bar exam, but there is a requirement that they have to take the bar exam. That's right. That is what's before us, correct?
That's correct.
Okay.
Right, so I had a question about, we received a lot of public comment about the PT, and I just wanted to know, did the Committee of Bar Examiners take this issue up at a time where we knew the full extent of the scoring issues, with PT, and just how different individuals did on, the rest of the exam compared to the PT? Can anyone summarize those deliberations?
In terms of the scoring remedies, in the presentation where they landed on the recommendation for that raw passing score, there was the first read data on the written sections across the board.
And then was there any sort of appetite at CBE for allowing a retest for individuals, who may have failed the PT by a certain amount, but scored higher in other portions of the exam?
That wasn't discussed in that meeting or on Monday.
So, and just to clarify, on Monday's meeting, at the time of the meeting, people had received their overall pass or fail, but they did not have the breakdown of that until Tuesday at noon, at the day after the CBE meeting. So I think you all heard, although CBE had absolutely heard quite a lot of public comment about the cut and paste functionality and how that significantly impacted people's performance on the performance test. What they didn't hear that you heard today was people pointing to the particular score they got on the performance test and how that related or not to how they've scored on prior performance tests, or how they reported that it related to how they performed on essay. So they didn't have that piece of public testimony because the breakdown of the results had not been received by the time of the CBE meeting.
That's a good point. They would have only had information in the aggregate.
So then if there was any appetite by the board regarding any partial retake, I would assume that would go back to CBE for them to study further and then make a further recommendation to us.
Aline?
You're on mute.
Would you mind repeating the question again?
Sure. If there was appetite by the board for any sort of partial retake remedy, especially involving the performance test, would the board then have to direct that issue to be sent back to the Committee of Bar Examiners for further study, and then submitted back to us for potential elevation to the Supreme Court.
If it pertains to the scoring adjustments, then the CBE, you could request that CBE review your recommendations, provide directions as you've done with the last meeting on these proposals. But on scoring adjustments and grading, CBE could directly forward the recommendations to the Supreme Court if we get indication from the Supreme Court that we should be submitting additional petition.
And what I think I hear, Chair Stallings, from you is, because part of me is trying to figure out how we would administer a new performance test, and the cost of doing that. So I may be putting words in your mouth because this is what I hope you're saying, is that you are suggesting consideration of allowing people, instead of taking the full exam in July, to just take the performance test and have that, and use that to substitute their performance test score from February, and see if that gives them a passing score.
I think that's a potential solution that we could discuss.
And I would think, I mean, that is right, applying one exam to another. So I would guess that the Supreme Court would need to weigh in on that.
All right, Trustee Tony.
I'm prepared to make the motion that is before us. That is to support the recommendation of the Committee on Bar Examiners. It's the version that's posted on the agenda as opposed to the one in the presentation we just saw.
Okay, okay, going over to San Francisco, do you have a second, or do you have a clarifying question?
No, I wanted to, I respect that Trustee Tony's ready to move it. I had another thought following up, Chair Stallings, on your discussion around what CBE heard, what they had available to them, which might be to suggest to CBE that they have another special meeting where they entertain public comment, and also that they listen to the public comment that we heard this morning about some truly bizarre results between the first reader and the second reader, the PT exam issues, some of these 1-point score differences. So in other words, two of the issues that Trustee Huser raised, one about the second reader and one about the 1-point score difference, and is there a narrow appeal process, and 3, the PT exam issues, and to have them very specifically look and examine that issue and decide if they want to make any recommendations to us about score adjustments or process changes based upon that, and then have that come back to us. Because for my part, while I heard some wacko results about the first reader and the second reader, you know, I also recognize that our executive director put up metrics that suggest that that often happens, that you do get that kind of disparity. And so I don't feel like I have sufficient information to make an informed decision to vote one way or the other. And so I think it would benefit from having CBE, with all of their testing experience, really dig into this issue that they wouldn't have been able to dig into on Monday, and then come back to us. And of course, we can then take up the provisional licensure suggestion, as Trustee Tony has said, separately.
Yeah, so what I heard was a potential second motion, and I don't know if someone on staff who heard that can start to craft something that captures Trustee Good's potential motion. So I want to get back though to Trustee Tony's first, or making the motion regarding the posted resolution on this agenda item. I'll look around. Is there a second?
Can we post the resolution so we can really know what they're talking
Do you
about?
want to share it, Louisa?
See my screen? Are you able to see my screen?
Yes.
Sorry.
Yes.
Okay, thank you.
If we could maybe zoom in on the one on the right, there we go. All right, so this is the resolution that trustee Tony has moved. Is there a second?
I'll second.
All right, second by trustee Swell. Trustee Tony, did you have a comment or another question?
I just moved the question.
Okay, I see your hand raised there, so just
No,
checking.
no, I'm sorry. I don't know how to use this Zoom very well.
All
but
right.
yes, thank you.
All right, trustee Barahona.
Just one quick question here on this second portion on 1B. It's recommending that the program lasts 2 years, but didn't the original PLP last longer than that?
No, well, yes and no.
Okay,
The original provisional licensure program, I believe the first incarnation of it was about 18 months.
got it.
But it was extended, twice. And so ultimately, the original program launched on November 17th, 2020, and is set to conclude December 31st, 2025. So ultimately, it was a 5-year program, but it was 18 months or so, then 2 subsequent extensions.
Thanks.
All right, any other questions?
Yeah.
Or comments? Yes, trustee Sewell.
Just want to say, I know I asked this before, but I just want to make sure that what's before us, if those folks that will go through this provisional licensure program, in order to become a fully licensed attorney, have to pass the bar exam.
Yeah.
Yes, that is correct. The reference to Rule of Court 9.49, that is the program that requires you to pass the bar exam in order to become licensed.
Okay.
All right, and I just wanted to offer just a couple of observations. This is based upon what I heard at the Senate Judiciary meeting on Tuesday. I don't think there was a clear support or opposition, either, clear majority who supported provisional licensure programs. We certainly heard from Chair Umbert that there were, I think I sensed concern in some of his questions regarding that program. Certainly, we talked about the incidents of reporting on PLLs versus attorneys. There were other members of the committee who supported broader pathways to licensure and really just wanted us to do whatever we could to make this right. So, we heard multiple things from Senate Judiciary. I don't think we've received any direction or any input from Assembly Judiciary, but just wanted to throw that out there for your consideration. All right, I see Trustee Buenaventura has joined us. Welcome.
Yes, good morning. Good morning, Chair and everyone. I'm sorry I'm not there, but I'm actually calling from the Philippines, and I have been listening, and I've not been able to step in because of the internet, what's going on. But I will just tell you that I've listened to the discussion and I am in full support of this motion. I thought it was important enough for me to at least try to make an effort to come to the vote. I think it's been a good discussion. I do believe that what has happened with respect to the mistakes that were made and the experiences that people were having, there is no perfect solution. However, this does offer a path. And again, it is simply a recommendation to the Supreme Court. They, as we all know, will make the ultimate decision, and we should give them as many options as they can choose from that make sense. And And so I understand there's been a lot of discussion, a lot of analysis, but in the end, I think this really comes down to fairness and a process to get people to practice law. And I think this provisional license program does do just that. So I will be supporting the motion. Thank you, Mr. Chair.
Thank you.
Chair,
Yes.
Chair Stallings, I have a
Trustee
question.
Harrison. Yep.
When would be the appropriate time to offer up an amendment to this resolution such that it would only apply to the candidates who took the February 2025 bar exam and not to the other 74 people who have been provisionally licensed for the past 4 years?
I think you could make that motion and then it'd be up to Trustee Tony if it was considered a friendly amendment.
Okay. I'll make the motion.
Trustee Tony, do you take that as friendly?
I would like the vote to be taken on this resolution as I stated, because and I'll tell you why. You know, this is the second time this has come to us from the Committee of Bar Examiners. The first time the provisional licensure proposal came, it had very little detail. Which was part of why I did not support it at that time. Okay. And this has the kind of detail I was hoping to see. And I feel that that in terms of there's value to when we can, I believe, for the Board of Trustees and the Committee of Bar Examiners to look for ways to express alignment. I mean, we're both part of the state bar here, okay? And so I guess to me, I would like to start off by giving them a little bit of deference, if you will, to what they recommended. And so for now, I would appreciate this being voted the way it was motioned and seconded, and we'll see what happens.
So just looking to our general counsel, if this is not a friendly amendment, would we then vote up or down whether the amendment is included at this point?
No, if it's not accepted by the motion maker, then I think the appropriate process on the Rosenberg rules is to vote on the motion that has been made and seconded. And if that motion fails, then another motion could be introduced.
All right. Trustee Buenaventura, I still see your hand, but I'm just going to assume that's from last question. Okay, any other questions or comments before I call for a roll call on the resolution as stated? All right, seeing none. Madam Secretary, can I have a roll call vote, please?
Farahona.
Aye.
Buenaventura.
Aye.
Cisneros.
Aye.
Good.
Nay.
Grande.
Aye.
Gore.
Aye.
Harrison.
Nay.
I'm sorry, was that a nay?
Nay.
Thank you. Huser.
Nay.
Soel.
Aye.
Stevens, not present. Tony.
Aye.
Trejo, not present. Stallings.
Aye.
That's 8 ayes and 3 nays. The motion carries.
All right, thank you. And then Trustee Harrison, did you have a motion?
No, I think we've already settled the matter, so we can just move forward.
All right, and then Trustee Good, I'm not sure if staff has had a chance to maybe capture what she articulated.
I have some language that I can share as a starting point. It's a little rough, but let me share that.
Was this your motion, trustee Good? I thought it was more specifically about the performance test. These things we heard, I think, from trustee Huser first. I mean,
Yeah, no, I suggested that the two items that trustee Huser raised should also go to CBE to consider, in part because, yeah, I think it all should go. And actually to this, I would add that other very troubling issue that came up about people getting copies of exam answers that they don't think they authored. I think CBE needs to look and hear about that, and as I understand it, they wouldn't have had the available detail before. And, you know, frankly, any other issues that came up, you know, in connection with people actually getting their test results, that would be new information to CBE. I think we would all benefit from having them take a look at it and then come back to us if they feel that there are other adjustments that should be made score-wise. Or maybe, I'm sorry, maybe I'm wrong, maybe it just goes to the Supreme Court. I mean, I would look to our general counsel to tell us how that would work out.
On the scoring adjustments, and these appear to be mostly pertaining to grading and scoring adjustments, the board's review would not be necessary.
Okay.
So it could go to the court. And Donna, if I could just suggest including earlier, you know, that was, if appropriate or required, submittal to the Supreme Court of their recommendations, that would be much appreciated.
Let's finish this additional thought.
So in other words, what this seeks to do is to say, we heard all of this public commentary about these troubling things that CDE wasn't aware of, and we're recommending that they really dig into it deeply and determine if there should be further adjustments.
Because I want to be mindful that we not pass a resolution that continues this discussion into perpetuity. So I don't know if there's a way to maybe limit.
I don't know if you want to provide any more guidance, like what like something like, you know, we want you to consider substituting the highest score during that second read process. Or the performance test, I think you have a specific idea maybe that people could take it in July, and that would substitute in. I think to the extent that you're comfortable giving that level of direction, it will help move the conversation forward. Because I think the test takers themselves really deserve to have some resolution of finality, particularly as they're considering whether or not they have to take the July bar exam. So that would be a reason to kind of put a little more meat around these if the board is comfortable.
And if I may also add, at the time that, you know, the CBE approved the lower passing score, raw passing score, and the petition articulated to the court that part of the reason why they took that approach was because there could not have been developed individual remedies and scoring adjustments based on an appropriately grouped and characterized experiences. And so some of that may have already been addressed by that prior consideration of this by CBE and also by the Supreme Court.
I think it's a fair point that they took an approach that applied broadly, but we heard in these, you know, dozens of public comments, some troubling things. And so I don't know if it's a resolution we need or a, hey, we heard these things in public comment. We want to pass this back to you in case you want to consider some individual circumstance, because these are individual circumstance, not broad things. And maybe they say, no, we already did that. But I think we heard these in the public comments, which is why I raised them.
Yeah, I think that's fair. Trustee Tony?
I appreciate this, the spirit of this resolution. I would ask, since we're at the stage of still discussing it, if we could think about replacing the word directs to either requests or recommends, just as they're colleagues. And I think colleagues speaking to each other, direct is just I don't want to get into an what do you call it? Who has authority game. And so that's my only recommendation. Thank you.
Thanks for not directing us to do anything. All right, Trustee Harrison.
Yes, for the first bullet point, second read scores that are lower than the first read, I would like to see a more pointed recommendation that the Committee of Bar Examiners consider adopting the highest of the two scores, whether it's the first read or the second read.
All right, I think I heard that from other trustees in the discussion, so I think that is a point well taken. And Trustee Good, I hope you're okay with us kind of modifying.
Yeah, I think we're all on the same page.
Okay.
So we're being collaborative.
Mm-hmm.
Does that work? I'm just gonna show it in strike through so you can, I don't take it away.
Mm-hmm.
Yeah, I just delete what you deleted.
I'm gonna go to Trustee Grande.
I just wanted to see if we could modify an appeal process and not necessarily a third read, but that we revisit those that came within a point, or whatever number they see, but not limit it to a third read.
All right, any heartburn regarding that?
Did you want to specify? I heard Trustee Grande say within 1 point. I don't know if that's.
No, I don't wish to specify. Thank you for asking.
All right, Trustee Barahona.
Yeah, I'm not sure if I got this right, but I do think that, is there a world that a recommendation can include taking a portion of the exam in July? For example, a retake of the PT section. I feel like I heard that, so I have that in my notes. I'm not sure if that's possible, but it seemed important to be able to, certain things worked well, but I think the PT retake seemed important.
Ms. Hershkowitz, I just point over to you, or Ms. Ching, to address that.
It's possible, Trustee Barahona, that what you're suggesting is for this third bullet to be more pointed. And it would be sort of consider whether there should be further adjustments recommended related to permitting a retake of the performance test only on July 2025 bar exam and applying that score to the
February 2025 results, right? Because it would be substituted in essentially.
Substituting for the performance test score.
Donna, if I can make a suggestion, could you make it in the first result clear that it applies to the February 2025 bar applicants?
I do think that related to the first one, I mean, this whole process for the second read I think this is the first time the board has ever considered at any level of specificity how this process works. And so with respect to that bullet, I don't know if the board might want the committee to consider that change more broadly. It is pretty shocking to see that the majority of the second read result is to actually decrease someone's score. And I throw that out there not to complicate things now, but just to say that that's an issue of kind of fairness, and I don't know, it just strikes the conscience a little wrong that that's what happens as a result of the second read. So it could be something that is considered more broadly.
And if I can clarify on that one, I'm assuming, well, no, that may be a bad assumption. It is, so the way second read works, you have 6 scores from first read, and then you get 6 scores on second read. Is the board suggesting the higher total, or is the board suggesting the higher for each question? Because that's different, and I just want to make sure we are clear in the resolution what the board wants on that.
Yeah, it was the higher for each item. That was what I was suggesting.
Not to belabor this more, but I was really, really troubled by the number of people who had accommodations who then didn't get them. And I know that's being separately handled, but maybe we could add that to the further resolved paragraph, because I thought, if true, it's indeed shocking and troubling. And I think CBE should take a look at that. So maybe to the further resolved paragraph, after test takers, we put, comma, that some test takers with accommodations did not receive those accommodations and other issues and determine, or something like that.
Trustee Good, if I may, I think there might be legal challenges with coming up with remedies that are specific to certain protected groups. I wonder if one way to accomplish that is to incorporate that in the appeal process for those that came near the pass line, that may include also those that, a broader group, and that they could review that a little bit more closely as part of a bigger group.
Okay, what language would you propose there?
I think it's broad enough to cover the pass line, or I think it would have to be a part of that particular group consideration.
And I do want to, again, just make sure that the board is clear on, so there are those you heard today who said that they were denied their extended time. There are also those who say that they were granted as an accommodation a reduced distraction room due to their ADHD, for example, and that due to some of the chaos that some people have described about the exam, they were denied the reduced distraction. So it's not as cut and dried as you were given extended time or not. So I just want to make sure that we have clarity on what the board wants us to be looking at.
I actually have an idea. Maybe it could be incorporated, Trustee Good, in the further resolved. So where it says that the Committee of Bar Examiner explored comments made that some test takers may have received answers that belong to others, and add their in denial of accommodations, and review whether any additional remedies are appropriate. So that may be
great.
Yeah, I think that may work.
All right. make sure we don't get too far ahead of Donna. All right, I think that looks good. Okay, I'd really like to make a motion here at some point. Trustee Barahona?
Thank you, Chair Stallings. Just really quickly, on those that have English as a second language, we heard that through the public comment, there being some challenge. Do you know if CBE has looked into this already before it gets added here? Has that discussion been had?
That's not something CBE has discussed.
Is that something, I think what you said, Aileen, earlier, I know, I'm not sure if it's considered as a protected class, but curious if that's something that they can dig into as well.
I think that last resolve includes other issues
Perfect.
that is broad enough. And Donna, if I may ask the adjustment to be changed to remedies, that would be great.
Yeah. 1 second.
Thank you.
All right, Trustee Grande.
Sorry, that was up from earlier. Sorry.
Okay.
Oh,
All right,
Make the motion, Chair Stallings, if you want.
perfect.
I'm sorry, where's that adjustment?
On the last line, it says if other adjustments are appropriate, I would change if other adjustments to remedies are appropriate. No, the last.
On your further resolve, Donna.
Yeah. Okay. Thank you.
Are we still leaving in this and other issues?
Yeah, I think so.
Okay. All right, so Trustee Good, is that your motion?
Yeah, that's my motion.
All right, do I have a second?
I second.
Good. Was that Trustee Tony? Or Trustee Harrison?
Let Trustee Harrison.
All right.
Thank you.
All right. Unless there's any further question or discussion, may I have a roll call vote?
I do apologize. Can I please, who made the motion?
That was Trustee Good.
Okay, thank you. And Trustee Harrison seconded.
Correct.
Thank you. Barahona,
Aye.
Buenaventura,
Aye.
Cisneros,
Aye.
Good,
Aye.
Grande,
Aye.
Gore,
Aye.
Harrison,
Aye.
User,
Aye.
Soel,
Aye, and I just want to say just good work on this. Thank you.
Stevens not present, Tony,
Aye.
Trejo not present, Stallings.
Aye.
That is 11 ayes, 0 nays, motion carries.
Right. Yeah, thank you to staff for keeping up with this, and then also thank you in advance to Committee of Bar Examiners for your continued care in these areas. I know Committee of Bar Examiners has put in a tremendous amount of work, and I hate to add to to their list of work, but I really think that this is important for us to get as right as possible and to do what we can. So really appreciate the work of the many members of the Committee of Bar Examiners and the many hours that staff has put into this and will continue to put into this. Definitely mindful that we're doing everything we can to ensure that July goes as smoothly as possible. So just again, want to thank staff for just the countless hours that you're investing into this. This concludes our open session items. And before we move into closed session, I'd like to clarify the closed session agenda item regarding 1.3. This item was originally posted as a discussion regarding initiation of litigation under Government Code Section 11126 sub E, sub 2, sub C. Since then, a lawsuit has been filed against Measure Learning. The item now qualifies as pending litigation under under section 11126 sub E, sub 2, sub A, and we will proceed under section 11126 sub E, sub 1 to confer with legal counsel. The case is State Bar of California versus Proctor U Incorporated, doing business as Measure Learning, Los Angeles Superior Court case number S as in Sam, T as Tom, C as Charlie, V as Victor, 13089. Additionally, the board will move to closed session pursuant to Government Code Section 11126 sub E sub 2 sub C to discuss and possibly take action regarding Mika's participation in the litany of cases that have been agendized, and Government Code Section 11126 sub A sub 1 to discuss the appointment process for the executive director. I do not have an estimate on when we'll come out. I know that I'm here in my the space that I'm at till 2:30, so hopefully we can be done by then. So 2:30 is kind of the estimate I'll give at this point, and we will go into closed session now. Trustees, you should have just received a closed session link, so exit out of this meeting and go to that other closed session link. All right, anything else before we log off?
Can we get a few minutes to eat?
When you say a few minutes, what are we talking?
10.
10? All right, let's take a 10-minute break. We'll come back.
5 minutes.
No? 5 minutes?
Can people just turn their camera off and eat?
It's not the eating part. I got to fix lunch.
How about if we go 7 minutes?
Fine.
Okay.
Okay, 7-minute break. You know, just an embarrassment of riches. I know, 7 minutes. So, all right, we'll go into the closed session. We'll come back into a closed session at 2 o'clock. Session or all right, this is the Board of Trustees coming out of closed session. There are several items to report on. I will report on one item, and then Vice Chair Cisneros will report on the second item for me to report on. Is that the Board of Trustees has established a search committee for the purpose of recruiting candidates for the executive director position, and the committee is comprised of the board chair, the vice chair, Trustee Sarah Good, Trustee Cynthia Grande, Trustee Arnold Sowell, and Trustee Mark Toney, with the board chair serving as the chair of the search committee. And it's further resolved that the Board of Trustees delegates authority of the board chair to negotiate and execute terms of employment for the deputy executive director to assume the role of interim executive director effective July 8, 2025 through the appointment date of the new executive director. That concludes my report out, and then I will sign off here. And then Trustee Toney will report out on the other item, and then if you could just adjourn when you're finished.
Sure. Thank you, Chair. I also want to report out that the board approved a public statement on the recent executive actions threatening the availability of legal counsel and the rule of law as part of its closed session considerations of whether to participate as amicus in ongoing litigation by law firms challenging actions of the federal administration. The statement will be distributed publicly after this meeting or early next week and can be summarized as follows. The State Bar reaffirms that attorneys have an ethical duty to provide competent representation, regardless of how controversial their clients' causes may be, and must exercise independent professional judgment free from external influences. Recent actions by the federal administration threaten these core principles. These actions imperil lawyers' ability to competently represent clients and create a chilling effect on availability of legal services, threatening access to justice and the rule of law. The State Bar encourages California attorneys to speak out in support of the right to competent legal counsel for all and of the rule of law. The board also approved amicus participation in the lawsuits challenging executive orders at the appropriate time. And with that, that completes the business of the California State Bar today. And with that, we will adjourn this meeting. Thank you, everyone.